Yes.
Please, Your Lordship. My Lord, Mr. M.U. Mahmood will be appealing for the petition of item number 1, my Lord. My Lord, he's making a mention in court number 17. He's on his way. Meanwhile, my Lordship may kindly hear for item number 2, my Lord.
Yes, please.
The here lordship is interlocutor appeal has come up for with a prayer lordship for suspension of sentence and grant of bail. Here the appellant was convicted under section 302, alleging that the present appellant, along with the other accused who is in item number 1 lordship, conspired to kill her husband lordship. And accordingly, 2 other persons were hired, and one of them was encountered, other is absconded. They hired them, and accordingly, the other 2 persons had killed the husband of the present appellant lordship. This is the prosecution case, and the entire case based on circumstantial evidence. Those circumstances were mentioned in the judgment itself. Just I am taking to your lordship to page 113
Which paper book?
of the judgment lordship. Appeal memo I have enclosed.
Which is your appeal? What is the number of the appeal?
Criminal appeal number 216 of 2022 lordship. Here 4 persons were charge sheeted. One lordship died in encounter, 1 is absconding, and 2 before your lordship. The petition appellant I am representing is the wife of the deceased. Page
1 minute. Yes, which paragraph?
Page 113,
Yes.
paragraph 200. Lordship will find.
Yes.
From 200 to lordship, 219 circumstances were discussed. So I am reading lordship 200. It is admitted that deceased Yad Ali is the husband of accused Srimati Lal Bhanu. This is the present applicant. It is proved by the prosecution that the accused Khandakar Safiur Rahman A1 and Srimati Lal Bhanu A2 have a very close relationship, and this closeness of relationship gives both of them the motive to eliminate Yad Ali. It is proved by the prosecution that the deceased Yad Ali was murdered and it was homicidal in nature, and the cause of death was due to hemorrhagic shock, excessive bleeding as a result of the multiple chop injuries sustained by Yad Ali. The death was homicidal in nature and caused by moderately heavy and sharp cutting weapon. One copy was recovered on the basis of the disclosure statement of the accused Ayub Ali, and the said thou answers the description of moderately heavy sharp weapon. One Becky was recovered on the basis of disclosure statement of the accused Abdul Khaled, and the said thou also answers the description of moderately heavy sharp weapon. The aforesaid 2 seized dows were shown to the PW 31, Dr. Navajit Bormon, and he had opined that the injuries sustained on the body of the deceased Yad Ali could be caused by such type of weapon. The mobile phone connections between the accused Khandakar Safiur Rahman, Srimati Lal Bhanu, Sri Ayub Ali, and Abdul Khalek, more particularly the increased frequency, just leading to the commission of the alleged offense. Just here, this is the only circumstance against me. Now I am just taking your lordship back to page 78. This is the page 78. Lordship.
Let us just finish this. Let us just-
Regarding this circumstance, it is discussed here. Therefore, I am Lordship.
Page 70.
At page 78. Paragraph 28, 128. Lordship. What was the conversation and timing that is discussed here?
Yes.
Paragraph 128. It is further seen from the perusal of CDR of the two mobile phones used by accused Sri Lal Banu that she made a telephone call to her husband Yad Ali on 6/7/2021 at about 9:06 p.m. and talked to him for about 12 seconds, and thereafter she made next call to Khandakar Safiur at 22:04 to the 31, that is 10:04 p.m. Lordship. And the aforesaid call was probably to confirm the kill of the aforesaid inference confirm the aforesaid kill, and the aforesaid inference can be drawn because when she called Yad Ali at 9:06 p.m. he might have told that he is on his way, and thereafter when he did not reach his house even after 1 hour, then she called Khandakar Safiur Rahman to confirm as to whether they succeeded or not in killing Yad Ali, because as it is already noticed that they tried to kill Yad Ali on chance, but they failed in the first two attempts. So there is no call details report, only CDR Lordship were produced. The conduct of Lal Banu is not telephoning her husband Yad Ali at 9 p.m. even though he did not reach home within a reasonable time, does not appear to be normal. And it can be inferred from the above conduct of Lal Banu that she was in conspiracy and was in the know how that Yad Ali was going to be killed and probably killed, and this explains as to why even when Yad Ali did not return home, Srimati Lal Banu initially did not make any call to the telephone of Yad Ali to know his whereabouts, but she made the first call to Khandakar Safiur Rahman at 10:04 p.m. and then she made a call to Yad Ali at 10:39 p.m. which was answered probably by the police or some other persons because it has come in evidence that by that time the dead body of Yad Ali was already discovered. So 3 phone calls were made initially at 9:96 minutes p.m. Thereafter 10:04 p.m. she made a call to the co-accused, and thereafter again at 10:39 she made call to the deceased Lordship. This is the only link. And the telephonic conversation, what was the conversation, that is not produced by the prosecution side Lordship. And now again, I'm taking your Lordship to page 114, Lordship, those circumstances. So my telephonic conversation was not found with the other two hired persons, Lordship.
Yes.
Paragraph 208, Lordship. The increased frequency of mobile phone communication between Abdul Khalik and Ayub Ali at around the evening time from about 7 p.m. to 10 p.m. That is the time when normally Yad Ali used to come from his duty on both the 3 dates, that is 4/7/21, 5/7/21, and 7/7/21, which shows that both Abdul Khalik and Ayub Ali were coordinating with each other so that the offense could be committed, and the large number of communication is also indicative of the fact that because the offense was committed on road, and so they might have been on the lookout for the victim Yad Ali and also on the lookout for other persons so that they could kill Yad Ali in isolation. The 3 mobile phone calls were made between Abdul Khalik and Ayub Ali after the communication of the offense, that is on 7/7/2021, very early in the morning, and this shows the conduct of the accused Abdul Khalik as he had to go to the house of Ayub Ali to hide his Bekida, which was later on recovered at his instance. The early morning communication was very abnormal and not usual because never in the recent past has the accused Abdul Khalik called Ayub Ali so early in the morning. And the above facts are revealed from the relevant CDRs. The recovery of SIM card number so-and-so broken SIM at the instance of accused Khandakar Safiur Rahman from behind his pharmacy from a bush. The fact that the SIM card number so-and-so broken SIM was used only on 4/7/2021, 5/7/2021, and 6/7/2021, and that too to communicate only with accused Ayub and Abdul Khalek, and no one else communicated with the above SIM. So here I am also excluded, Lordship. Ayub Ali and Abdul Khalek, and no one else was communicated with the above SIM, and soon after the commission of the offense, the above SIM was broken and thrown away in such a place that no one could even accidentally have discovered the same. The recovery of the mobile phone and SIM card bearing number so-and-so from the possession of accused Ayub Ali, which phone number was used in the commission of the alleged offense to coordinate. The recovery of the mobile phone and SIM card bearing number so-and-so from the possession of the accused Abdul Khalek, which phone number was used in the commission of the alleged offense to coordinate. The recovery of mobile phone along with SIM cards bearing number so-and-so from the possession of accused Lal Banu, which phone numbers were used to communicate with the accused Khandakar Safiur Rahman. So my communication was only with co-accused, Khandakar Safiur. Because prosecution says we have love affairs. The recovery of mobile phone along with SIM cards bearing numbers so-and-so from the possession of accused Khandakar Safiur Rahman, which phone numbers were used to communicate with the accused Srimati Lal Banu and Abdul Khalek. The frequent communication between Khandakar Safiur Rahman and Abdul Khalek nearer to the time of commission of the offense. However, very negligible communication between Khandakar Safiur Rahman and Ayub Ali, which proves that Khandakar Safiur Rahman had direct contact with the hired Abdul Khalek to commit the offense, and so majority of the communication was done with him. The location of accused Ayub Ali and Abdul Khalek was found near each other just prior to and during the time of the alleged offense. The knowledge of the accused Abdul Khalek that the Bekida was kept hidden underneath the haystack and that too at the house of Ayub Ali. The recovery of the dawah of Abdul Khalek from the house of Ayub Ali also points to the complicity of both the offenders in the commission of the offense. So these are the circumstances. From here, only my implication is that
Forensic report, FSL report.
nothing else. No, that conversation is not proved. Only that CDR, that my phone goes to him and to the deceased. What was the conversation that is not proved by them?
No, but how can that be? Is that
That recording remains for 6 months.
every conversation
Every
record
conversation
remains?
remains with the operator.
Hmm.
So only this is a presumption that I might have conspired. So there is no other material
What
to
is
show.
the stand of the applicant in the 313?
A denial.
And what about the other accused? What did he say?
Probably he also denied.
So he simply said false, and the Lal Banu said that she never called in those mobile numbers. And the Khandakar said false. It is reflected in the judgment itself, page 130, paragraph 138. Lal Banu merely denied and stated that she never used the aforesaid mobile numbers, and the accused Khandakar merely stated it is false.
Yes, so what is your submission?
My submission is before your lordship is that the circumstance regarding circumstantial evidence, it is already well settled and your lordship judgment is also there that the circumstances which is relied on by the prosecution that has to point the guilt of the accused towards the offense, lordship. Here the only the communication, it does not show whether the conspired or whether it is due to the love affair between them, lordship. These communications were made. So there is no concrete evidence to show that she conspired with the co-accused to kill her husband. Because prosecution is saying that there was love affair. So that call details report due to love affair or due to conspiracy, that is not clear from the evidence. So the circumstances relied on by the prosecution is not sufficient to convict the
So applicant was in jail during trial
during trial, yes. During trial on bail.
and thereafter from the date of the judgment.
The judgment.
Let us hear Mr. Miller.
May I please lordships. My lord, first thing is this, my lord. As per section 62, the call records are not produced, voice sample were not examined. Who made those communications? Second thing is this, every point of the case has been taken for conviction on the basis of circumstantial evidence. Now, the best circumstantial evidence, I may draw lordship's kind attention to the deposition of PW11, Rasul Khan. Now, Rasul Khan is the only circumstantial witness who said in a better manner, trying to implicate PW11. I am reading my lordship's kind perusal. About 3-4 months ago, PW11 Rasul Khan. One night at about 11 p.m., I was at my house at Bizni town, and then I received a telephone call informing me that a dead body has been found at Bhandara, Kajdoha Road. On getting the information, I rushed to the place of occurrence and saw a dead body lying by the side of the road. When I reached the place of occurrence, there were many other persons who had gathered there. I did not go very near to the dead body. As such, I cannot say about the injuries. The police was also present before I reached the place of occurrence. The police seized one bicycle, one torch, sandal, a slipper, an umbrella, a mobile phone, mask, a K from the place of occurrence. Exhibit so-and-so is the seizure list by which the above articles were seized. Exhibit P41 is my signature. Material exhibit MI is the said bicycle. Material exhibit M2 is the nylon carry bag. Material exhibit M3 is one black color umbrella. Material exhibit 4 is one pair of sandal. Material exhibit 1 is face masks. So these are the things. Now there is no whisper to whom these articles belong. That is a very important thing. Now the PW 34 and 35 level. I am drawing a lot of kind attention. PW 34 and 35. They are the officers of the electronic department. My lord, this first 34 is my lord, Maibong Basant Singh. He examines several mobile numbers. Lastly, lordship would see in cross. I don't use any seal for my signature. My name is not tied beneath my signature marked at exhibit P21-1, exhibit P29-1 or exhibit P32-1. I merely generate the call detail report from our computer system, but I did not analyze the call detail report. I did not mention the name of the owner of the phone numbers in my certificates. Now, my humble prayer is this, the same thing exactly, PW 35 Gautam Datta. But he also said this exactly same thing. I did not mention in cross the name of owner of the phone numbers in my certificate. Now, my lord, they are the best person to certify to whom the mobiles belong. Now, both these persons are saying that we have not mentioned to whom these mobiles belong. Now, does it mean that those mobiles are ours? They are the best person. They are saying we don't know whose mobile belong to. So there is some not lacuna, very serious lacuna on the part of the prosecution case. Thirdly, my lord, the place of occurrence, from police station to Bijli court, there are several judicial magistrates, my lord. But surprisingly, my lord, none of the witnesses' statements were recorded under 164 of CIPC. It is said that they have confessed before police, before sweeper, before some businessman. It is the version of the prosecution witness. I humbly submit, my lord, is it not a serious defect in the investigation of the case? Prosecution wants to hide something. So never which is hardly 200 meters from.
Please take your seat, Mr. Mahmood. Yes.
This is a case, of course, where circumstances lordship had seen, called and CDRs becomes very important here. The way they communicated with each other, not only Khondokar and Lal Banu, but with the other contract killers.
But he's saying the ownership of the SIMs were not established properly.
But this is what they say, the 3 SIMs were, lordship will see 3 SIM cards were recovered, exhibit for P23, 24 and 25. Those were of applicant, those were recognized. Exhibit number P23, 24 and 25, those were of Khondokars. Then wife PW20, exhibit 21 and 22 belongs to the wife. 26, 35 were to the killers, they were all recognized.
What happened to the killers? Alleged killers?
One absconded, one died.
Died how?
There was an encounter. It is in the evidence. What kind of an encounter, that is not clear. But communications were there immediately before the death with the wife and Lal Banu and Khondokar, even with contract killers. There were so many communication between Ayub Ali.
That's the only basis.
The
Communication,
yes.
which according to them, it has not been proved.
Yes, they say it is not being proved, but of course, what calls they made there, this is not there. But the calls were made to those phone numbers, those were established. Along with that, the recoveries of the weapon and SIM card, one SIM card he had broken and threw it behind the temple. That was also recovered at the instance of Khondokar. Khondokar's SIM card. So those were there. The illicit relation, that is also writ large.
Illicit relation has been proved.
That is in the evidences of the witnesses. That is, this is how they initiated the investigation, because at first they I think arrested only Khondokar. Then wife's name came into the picture. Then they had revealed the names of the contract killers. That is how investigation proceeded. And
Who had revealed the name of the investigator?
both of them, this is what has come. They had revealed the names of Ayub Ali and Khalek, the 2 contract killers. Of course, we have to go deeper into the matter. Now at this stage, it will be difficult. Police have said these SIMs belong to them. Now, what kind of a recognition, whether it was properly done, this has to be again seen.
May I reply some points raised by my learned friend?
Take your seat. On bail for now, we'll see. In criminal, in IA number 442/2022, you take the order, then put his name in the other IA and change the which is your IA, Mr. Ahmed?
506 of 2020.
506 of 2022, this order. Heard Mr. A. Ahmed, learned counsel appearing for the applicant. Also heard Ms. S. Jahan, learned APPSN representing the state. Full stop. The applicant herein, namely Lal Bhanu, along with another accused person, namely Khandakar Saifur Rahman, were convicted under section 302(120)B of the IPC for committing the murder of deceased Yad Ali pursuant to a criminal conspiracy and sentenced to undergo rigorous imprisonment for life and also to pay fine of rupees 20,000 with default stipulation. Stop. The prosecution case in a nutshell is that the applicant, who is the wife of the deceased, had conspired with the accused, the applicant bracket A2, who is the wife of the deceased, had conspired with Khandakar Saifur Rahman bracket A2 to kill her husband by engaging two contract killers. Stop. Pursuant to such conspiracy, the husband of the applicant was in an incident which took place late in the evening of 7/7/2021. Full stop. The prosecution case is entirely based on circumstantial evidence. Full stop. A perusal of the impugned judgment indicates that the learned trial court had heavily relied upon the CDR, call details report, bracket CDR, of both the accused persons and the contract killers around the time of the incident to come to a conclusion that the incident was the outcome of a criminal conspiracy. Full stop. According to the prosecution, the applicant Lalbanu was maintaining an illicit relationship with the accused number 2, Khandakar so-and-so. And in order to materialize their illicit affair, in order to continue with their illicit affair, the deceased was eliminated. First up, Mr. Ahmed has referred to the evidence considered by the learned trial court to submit that the prosecution has failed to produce the voice sample or the detail of conversation which was available with the operator at the time of investigation. Stop. According to Mr. Ahmed, there is no evidence to establish the illicit relationship between his client and the co-accused. Full stop. Moreover, the ownership of the SIM cards relied upon by the prosecution also could not be established by leading cogent evidence. Full stop. According to the applicant's counsel, the prosecution has failed to establish the charge brought against the accused applicant beyond reasonable doubt, and hence there is a strong possibility that the applicant would be acquitted in this case. Full stop. On such count, a prayer has been made for granting bail. Full stop. Ms. Jahan, learned APP Assam, on the other hand, submits that the learned trial court had relied upon materials placed on record, which includes the CDR as well as the broken SIM card and the weapon which was recovered by the police. Full stop. However, whether such material will be sufficient to sustain the charge is a matter that can be gone into during the final hearing of the appeal. Full stop. After hearing the submissions of learned counsel for both the sides and on perusal of the materials available on record, We also find that this is a case entirely based on circumstantial evidence, and the conspiracy theory has been sought to be established by the prosecution merely by relying upon CDR. Whether the CDR has been proved by adducing cogent evidence and what impact the failure of the prosecution to produce the conversation and the voice sample, if any, of the accused persons is a matter that has to be looked into minutely during hearing. First of all, however, having regard to the peculiar facts and circumstances of the case, we are of the opinion that the applicant has made out a good case for allowing her to go on bail. Full stop. We accordingly direct that the applicant Lal Bhanu released on bail on furnishing a bond of rupees 50,000 and 2 local sureties of like amount to the satisfaction of the learned trial court, with the further condition that she would not leave the jurisdiction of the learned Sessions Judge Bijni Chiram without prior permission, and shall also record her presence before the learned trial court once every month. Full stop. With the above observation, the IA stands disposed of. Same order in the other IA, we'll just change the names, and here you will write accused number 2 is the deceased of the accused. Yes.
Hello. Additional session. Additional session judge.
Additional session.
The name of the one number accused, Khandagar Safiur Rahman. Our highly obliged.
For hearing matter whether item 3.
In this case, Lordship, my learned friend is appearing. He has requested me to argue on his behalf. If your Lordship permits, then I will advance the argument. Lordship. Lordship, may kindly see the last order passed by your Lordship in this case. Here in this case, Lordship, just I have found one judgment of Allahabad High Court, Lordship. Here, Lordship, the appellant was tried under section 302 and 304B. And thereafter, he was acquitted from 304B and convicted under section 302. But after hearing the matter, the Honorable High Court found that there are materials that which suggest that there are ingredients of section 304B. But as it has, the trial court has already acquitted the appellant, and there is no appeal against that acquittal, that findings cannot be disturbed. That observation was made here, Lordship.
That is exactly what we were also thinking.
Lordship.
Even I was thinking about that. There is no appeal against acquittal. But your lordship, in the appellate stage, your lordship may reappreciate the.
No, reappreciate means that is the point here.
Yes,
If you find 302 has not been made out,
yes,
he has been acquitted of the other charge.
yes.
So that acquittal cannot be converted unless there is an appeal.
Yes. That
And
is-
therefore, we have to observe that this is a lapse on the part of this case.
That aspect I have thought about it.
These criminal proceedings are happening, the lethargy of the state in many ways is absolutely visible. Every case is fit for acquittal. No prosecution, no investigation, nothing. We'll have to write elaborately that
Yes,
this is
ma'am.
what is happening.
Yes,
Why don't you prefer an appeal against acquittal even now?
you can, but
Yes.
it takes some time. I have to take lordship instruction from the LR. Then thereafter.
But Mr. Ahmed, those days are gone. That merely on technicalities will let people out.
Yes, that I
That this
understand.
court is not allowing.
Lordship, that I understand.
You
And
need to
apart from
challenge
the-
it in the Supreme Court to have that law resettled.
Correct.
Because there is lethargy on the part of the IOs. They do it deliberately or they don't know how to do it. Prosecution doesn't know how to conduct a case. The judgments are written on absolute fallacious grounds. But if we find that leaving aside all these things, there are materials to suggest that this is a case which comes within the fold of a provision, then merely because some prosecutor doesn't know how to prosecute, some IO doesn't know how to investigate, and some judge doesn't know how to write a proper judgment, we are not going to let people off.
That I understand, Lordship. Here on
That is
merit
not
also,
happening.
Lordship, I have submission, Lordship. From the record, what I find, Lordship, the demand, which is that about, it is said that 34,000 rupees was demanded by the accused. And the person who gave the amount, the relative said it was given to him for business purpose. And I have citations of Honorable Appeals Court where it is said if it is given for business purpose or to help them in financial condition, Lordship, that will that does not amount to dowry, Lordship.
You are correct.
Lordship,
That the witnesses himself say,
Lordship.
this was given at the time of the marriage. We are not bringing that in. After that, there are allegations of cruelty and demand.
Yes.
What do you say about
After
that?
There was no demand.
There
After that,
was-
there was no demand. In my humble.
Ms.
submission.
Bhuya, can you just show him that part?
Lordship, evidence of PW1, PW2, PW1 say tortured by in-law family demanding dowry. Coming to her house, accused Karimul demanded dowry.
Hmm.
Accused killed for demand of dowry, all in evidence of PW1. All the neighbors of accused Karimul know that Hafizuz was tortured for demanding dowry. Accused Karimul was present in his residence, that part is there. Nashiba, PW2, accused Karimul and Naimuddin torturing my daughter. Since after her marriage in demand of dowry. That is there in evidence of PW2.
So regard-
Jotted down the whatever is there on evidence.
Regarding this, the submission made by my learned senior friend, those are contradictory facts from the evidence what I find. Just I'm taking your lordship to page 25 of the paper. Page 25
Yes.
is the just examination in chief. I am reading that part, lordship. I know accused Korimul and the other accused person. The informant is my brother-in-law. About 2 years and 3 months ago, my daughter Hafiza passed away. Prior to 3 years of the incident, I gave my daughter Hafiza in marriage to Korimul. At the time of marriage, accused Korimul demanded 34,000 rupees in cash, gold earrings, silver chain, gold bangles, and accordingly, we gave these articles with Hafiza at her marriage. Even after the marriage, Hafiza and Korimul were on good visiting terms to our house for 2-3 months. Since then, accused Korimul harassed my daughter for money and sent her to bring the money. Then I again gave her some amount of money and sent her back. In the meantime, accused Korimul went to Guwahati and he got married for second time and came back home with her. This time Hafiza came to my house and said that since Korimul got married for the second time and brought his second wife home, she would not go there again. So reason was that the appellant got married for second time, therefore she went to her relative's house. Now your lordship will kindly see, that time Hafiza stayed in my house for 9 months. So during this period, whether demand was there, whether any torture was there, nothing on record, lordship. During that time, Korimul came to my house and stayed in our house that day. On the following day, two younger sisters of accused Korimul came to our house and I sent Hafiza to their house. But after 2 weeks, one day, at the time of Ramadan fasting, at the time of taking Shahri, two persons came to our house and informed that Hafiza's daughter was ill. So after that, this incident occurred. Till then, he was in his house. And there is nothing on record to show that during this period, any demand was made, Lordship. Or she was tortured. Because he is saying, prosecution witness saying that for last 9 months, the deceased was staying with him, Lordship. And in cross your lordship will find, accused Korimul was engaged in vehicle business prior to the marriage. Therefore, prior to the marriage, he said that since he has to pay installment for his vehicle, if we give him 34,000 rupees in cash, he will marry our daughter. Then we agreed with the accused Korimul and gave our daughter Hafiza in marriage to the accused person. And if I read the evidence of PW 1 and 2, Lordship,
Yes.
your lordship will find that there was initially there was a dispute. It is admitted, it is stated by the PW, but it was settled. They say it was settled, and subsequently there was demand and torture that is not on record, Lordship. PW 1, 2 both all say, Lordship, that it was settled.
So let us read PW 2 once.
Lordship. I know the accused persons. Page 15, Lordship. This is Hafiza was my daughter. She was married off to accused Korimul Islam. She expired 3 years after her marriage. The incident took place about 2 years back. Around 3 a.m. that night, accused Arman Ali along with a boy came and informed me that my granddaughter, that is Hafiza's daughter, was not well. On being informed, my wife Ankamala and I went to Korimul's house to see our granddaughter. On our arrival, we found that our daughter Hafiza was killed and her body was left on the steps to the pond situated in between the house of Arman Ali and Noimuddin, and our granddaughter was not unwell. Then I went close to Hafiza and saw mark of squeezing on her neck and in the upper portion of her left arm. Blood was oozing out from her ears and nose. Fourth, and blood were coming out from her mouth. I saw accused Noimuddin and Korimul sitting in their house. Accused Noimuddin, that is my daughter's father-in-law, and my younger brother Soiful lodged Ejahat, and police from Sorbog police station came and took the dead body away. While marrying Hafiza off to accused Korimul, I gave an amount of rupees 34,000 in cash, gold earrings, silver chain, and gold bangles as dowry. Accused Korimul and his father Noimuddin had been torturing my daughter a lot since after her marriage in demand of dowry. I am a chowkidar in a school, and I fulfill the demands of the accused persons by giving them money occasionally. I gave them 25 mounts of paddy. The depth of the water in the pond on the bank of which Hafiza was lying was only 1 foot, and the incident occurred in the month of Ramadan. I found my granddaughter crying at the courtyard and nobody took care of her. She was then 9 months old. That day, I saw Karimul and his father in the house of the accused. His mother fled away. Accused Arman Ali went to inform me. He is the maternal uncle of accused Karimul. PW1 is my younger brother. Accused Osman, Nur Hussain, Arman, and Surman are the maternal uncle of accused Karimul. They do not live in the house of the accused. They live in separately house, but their houses are adjacent to each other. I reached the house of the accused Karimul at about 3:30 a.m. on the day of the occurrence. On my arrival at the place of occurrence, I found Karimul and Noimuddin only. I did not see other persons, and at that time I was not in a conscious mode as I was crying. On being informed, police came to the place of occurrence at about 10 a.m. by vehicle. They saw the dead body and questioned me. People gathered at the place of occurrence after police had arrived there. When I came to the house of the accused person, my son also followed me to the place of occurrence, and again he returned home and informed Saiful. Around 10 a.m., my younger brother Saiful came with police. Just here, I'm pausing for a moment, Lordship. This is the Lordship. Here, this part is important because initially the father of the father-in-law of the deceased and the PW2 went to police station. They informed the police. One GD entry is also there on record, so I will place that. There said another person is suspected that he has killed the daughter, and subsequently this Soiful, he went at 2 p.m. to the police station and lodged the FIR on his own. Thereafter, this whole incident turned. When I came to the house of the accused persons, my son-in-law followed me to the police place of occurrence, and again he returned home and informed Saiful. Around 10 a.m., my younger brother Saiful came with police. Before I came to the place of occurrence, Saiful told me, "Go, perhaps your daughter or granddaughter may be there." Later, the accused and I went to police. Police questioned Saiful, neighbors, and me. Around 3 p.m., Saiful lodged the written azahar with the PS. Police had already started the investigation. Police arrested accused Karimul and his father Noimuddin that day itself. Accused Aliza is accused Karimul's sister and Noimuddin's daughter. The matter of giving rupees 34,000 in cash and gold and silver ornaments such as earrings, chain, bangles, etc. was decided at the time of negotiation of the marriage, and the marriage was finalized accordingly. The accused person said that the marriage would not be solemnized if cash and gold and silver ornaments were not given to them, and owing to that, I gave cash and gold and silver ornaments. I was not forced to give the materials and money at the time of marriage. PW1, Soiful knows the matter of giving money and gold and silver ornaments. Several meetings for extrajudicial settlement were held in our village regarding the demand of money made to Hafiza by the accused, and Headmaster Khalilur Rahman remained present in one such meeting. Headmaster Khalilur Rahman knows well about the demand of money made to Hafiza by the accused person. Kolgasia police outpost is situated about 2 miles away from our house. We lodged azahar neither with the police outpost nor with the police station with regard to the demand of money made by the accused persons. Saiful was not aware of the meetings for extrajudicial settlement, but PW1 said he attended various settlement meetings. I did not discuss the matter of holding meeting for extrajudicial settlement in the school with the informant. My younger brother Saiful, accused Noimuddin, was present in meetings for extrajudicial settlement. Accused Noimuddin know about meetings for extrajudicial settlement well. At the time of meeting for extrajudicial settlement, Muhammad Master Nur Alam, Abdul Khalek, and a girl named Lavanya Das of the school were present, but daughter Hafiza was in the house of her daughter. Korimul was not present, but his eligible was not present. Accused Korimul sometimes went to Guwahati to work there, and he remarried a girl there. The incident took place in winter season. The incident took place in the month of August. The incident took place on 27/8/2009. The Azhar was lodged on 28/8/2009. It is not a fact that I did not state that several meetings for extrajudicial settlement were held with regard to the demand of money. It is not a fact that I did not state to police that I gave 25 mouths of paddy to the accused when Hafiza was alive, and that sometimes I gave money to the accused. It is not a fact that I did not state that at the time of
Give the IPC. Yes. Yes, continue.
And that it is not a fact that I did not state that at the time of the occurrence and the pond had 1 foot deep water. Accused Korimul's neighbors were well aware of the incident about demanding money from Hafiza by accused. Nawab Ali, son of Goni Master and a cow trader, I do not remember his name, now know about the demand of money. 15 days prior to the occurrence, accused Korimul came to my house and brought Hafiza from my house. That day, accused Korimul denied in our house. Accused Korimul quarreled with me and my wife. Then Hafiza told us that she would go to her husband's house and would come back after some days. After Hafiza's departure from my house that day, I did not make any inquiry about her. I thought Hafiza would live peacefully in her husband's house. It is not a fact that I did not state to police that I saw mark of squeezing injury in deceased Hafiza's neck and shoulder. I do not remember on which date, the month, and how much money the accused persons had demanded from Hafiza. I offered 25 months of paddy to accused Korimul and Hafiza. I gave an amount of rupees 34,000 to accuse Korimul for doing business. This was what I am placing for lordship. Accused Korimul did not repay the money to me. I gave accused Korimul 34,000 so that he would be financially sound and my daughter would live happily. I did not witness how Hafiza was killed, but I saw mark of injury caused by hands clearly. It is not a fact that the accused persons neither demanded money from Hafiza nor they killed her, that I have adduced false evidence for the sake of my daughter, and that I have falsely deposed that the pond had 1 feet deep water. Cross-examination, PW2, pardon. I know witness Tarabano. Tarabano is PW6. She did not support prosecution side, lordship. Rather, she supported the defense side. At the time of incident, Tarabano was at home. I know witness Chand Khatun. She is PW7. I also know witness Eliza Khatun, PW8, lordship. She is the wife of Noimuddin. At the time of the incident, Eliza Khatun was at home. These three witnesses know well about the incident. Deceased was my own daughter. I did not witness how the deceased died and who had killed the deceased. The neighbors know how the deceased was treated and how she lived in the house of her husband. My house is situated about 3 kilometers away from that of the accused person. The family of the accused was in visiting terms with us until the death of my daughter. Accused Korimul demanded dowry. We treated Korimul affectionately as our son-in-law, but he did not show any respect to me as his father-in-law. I went to the house of accused several times. The members of the family of the accused did not talk to me much. I did not witness who killed the deceased. PW3.
Yes.
I know the accused persons. I knew this is Hafiza. Hafiza was my niece. PW1 is my cousin, son of my maternal uncle. Hafiza and accused Korimul were given rupees 34,000 as dowry. Gold earring, bangle, and silver chain were also given. She was married of 3 years before the incident. After 1 year of her marriage, the accused Hafiza's father-in-law Noimuddin and mother-in-law Eliza Khatun tortured and assaulted her in demand of dowry. Before 2-3 weeks of her death, Hafiza came to our house and said that she was assaulted for dowry and would not go back. Hafiza told us that Korimul remarried in Guwahati. While accused Korimul was in Guwahati, his father came to bring her back.
Just a minute, can you please ask the public prosecutor to come once?
Yes.
Yes. Yes,
Hafiza told us that Korimul remarried in Guwahati. While accused Korimul was in Guwahati, his father came to bring her back. When he was asked whether Korimul had remarried in Guwahati, accused Noimuddin said that Korimul's her second wife would not come here and we convinced Hafiza to go back and send her with Noimuddin. Here also your lordship will find that dispute was regarding second wife, not that demand and torture, lordship.
no, but it is before 2-3 weeks of her death.
Yes,
Hafiza
sir.
came to her house and said that she was assaulted for dowry and would not go back. That part is also there.
No, that is not in 161. That is confirmed by IO. Page 44, your lordship will find that part.
Mhm.
Confirmed by IO, that is.
Yes.
About 2 weeks of her departure, accused Arman came to the house of PW2 and informed that Hafiza's daughter was unwell. Then PW2 and his wife went to the house of accused. It was the time of taking sehri, meal, then before keeping fast in the month of Ramadan. I did not go. In the meantime, the villagers informed the family of PW2 that Hafiza had died. Getting the information, I immediately went to the place of occurrence and saw Hafiza lying dead on the steps on the bank of the pond of the accused persons and her mother-in-law sitting beside her. When police arrived, Hafiza's mother-in-law Kamila Khatun disappeared. I observed the dead body of Hafiza and saw a black squeezing mark on her neck and on the upper portion of her right arm. Forth was coming out through her nose and blood was oozing from her mouth. Police came to the place of occurrence and held inquest on the dead body in my presence, and I put my signature. The dead body was taken away for postmortem examination. Cross. Accused Noimuddin brought his daughter-in-law Hafiza to his house before 15 days of the incident. He came alone, but accused Korimul was at his house itself. PW2 and I have separate houses. When accused Noimuddin came to bring back Hafiza, I too was present at the house of PW2. Eligible Khan Abdul Halim and we 4-5 brothers were also present at the house of PW2 when accused Noimuddin came to bring Hafiza back. The incident took place in monsoon season. I do not remember on which date, in which month, and how much money was demanded by accused person, and no case was lodged with Kolgasia PS in this regard. There was no cordial relation between the two families due to the demand of dowry made to Hafiza by the accused persons. I came to know about the matter of dowry from the deceased. It is not a fact that I did not state to police that girl came home before 2 weeks of the incident, that she said that she was assaulted for dowry and she would go to her husband's house again, and that accused Korimul remarried. It is not a fact that I did not state to police that accused Noimuddin came to bring Hafiza back, that Noimuddin said that Korimul remarried and that when he said that He would not allow Korimul's second wife to come to his house. We sent Hafiza with her father-in-law. PW2 Abdul Rahim Bhuya knew well about accused Noimuddin bringing his daughter-in-law Hafiza from the house of PW2 for the last time. It is not a fact that I did not state that on my arrival at the place of occurrence, I saw accused Promela sitting beside the dead body of Hafiza. First, a person informed the family of the PW2 that Hafiza's baby was unwell. I got the information in the early morning on 24/4/2009 that Hafiza had died in the house of her husband. It is not a fact that I have adduced false evidence. PW4. I know the accused persons. Deceased Hafiza was my granddaughter. She was married off to accused Korimul 3 years before her death. An amount of rupees 34,000 and ornaments were given to Hafiza as dowry. Hafiza came to her mother's house times after her marriage. I heard that Korimul remarried and would not continue the conjugal life with Hafiza. In the morning on the day of occurrence, we were informed that Hafiza's baby had died, but going there, we saw that it was Hafiza who died. I saw injury on Hafiza's body. Blood was oozing out from her ears and nose. I saw injury in the upper portion of her left arm and neck. Police came to the place of occurrence and questioned me. Hafiza was brought from her father's house 2-3 days before the incident. I do not know who had brought Hafiza from her father's house before her death. There were differences in the family of Hafiza's father-in-law and meeting was held several times for sorting out the differences, but I do not know the reason for differences. I never went to such meetings. It is not a fact that I did not see marks of injury on Hafiza's neck and hands. An amount of rupees 34,000 in cash and ornaments were given in Hafiza's marriage with the agreement of both the parties. I did not state to police that blood was oozing out from the Hafiza's nose and mouth, that I saw injury in Hafiza's neck and hands, and that an amount of rupees 34,000 was given at the time of her marriage. PW5 already I have read.
He's on legs and couldn't.
All right.
Lordship, may skip PW5 already. I have read that.
Yes.
PW6, Lordship, may I read? I know the accused persons. I also know the informant. Accused Usman is my husband. About 2-3 years ago, accused Korimul's wife Hafiza Begum died. I do not know as to how Hafiza Begum died. There is road in between the house of the accused Korimul and mine. Around 12 a.m. on the day of the incident, accused Korimul's mother and his father went to call us and they searched for Korimul's wife Hafiza. Hafiza was not in our house. Then I came to know that Hafiza was not in the house, and later I saw the dead body of Hafiza lying in the pond of neighbor on that night itself. I did not see any mark of injury on Hafiza's body. Many people searched for Hafiza. Since the incident occurred during monsoon, the pond was filled with water. Later, when the dead body was found, it was lifted from the water. Hafiza and Korimul got married before 2 years of the incident. I knew that they led a happy married life. Although Korimul got married to another woman, I knew that she was not taken home. Later, police took away the dead body for holding postmortem examination. Cross. Accused Usman is my husband. Accused Nur Hussain, Arman, Surman, Ali, Surman all live separately. They do not stay with the family of Korimul. They are all nephews in relation. The pond on which the dead body of Hafiza was recovered was adjacent to the house of Korimul. There are ponds in both sides of the road and there is an approach road to the house of Korimul along the side of the pond. At that time, since it was monsoon season, the pond was about 15-20 cubic. Occasionally, we went to the house of Korimul and meet Hafiza also. This is Hafiza knew me well. I had conversation with her. This is Hafiza never told anything before me against her husband, father-in-law and mother-in-law. Hafiza lived happily with her husband, father-in-law and mother-in-law, and they also cared about her. Accused Korimul is a driver. Since accused Korimul drives vehicle, he stays outside for 15 days in a month, and thereafter he come home. On the day of the incident, accused Korimul was not in his house. Since 1 week before the incident, accused Korimul was not in the house, and around 8 a.m. on the following day of the incident, he was informed about the incident and then he came to the house. There are chances of drowning if a person does not know swimming. Hafiza do not know swimming. There are ponds situated in both sides of the road, which leads to the house of Korimul, and there is no fencing in the side, and it is the only road that leads to the house of accused Korimul. When we found the dead body of Hafiza in the pond, we lifted the dead body on the road by holding together and tried to expel the water from her body, assuming that she was alive. But water was released from nose, ear, and even from the mouth of Hafiza. And at that time, commotion arose among the people, and they talked among themselves that accused Korimul's wife, Hafiza, died by drowning in the pond. After expelling the water from Hafiza's nose and mouth, I saw her body. I did not see any injury in any part of her body.
So PW 6, 7 and 8, they are relatives of the accused.
Yes, but they were
They should not have
victims.
been examined as prosecution
Yes.
witnesses. They have come and supported the defense case. So in a way, technically, they are not, but essentially they are hostile witnesses. This has been done because the prosecutor didn't know how to conduct a prosecution.
Right.
And you will get the benefit of it.
Right.
That's the system.
They are not-
This criminal justice system is a mockery. All that at the high court level a lawyer needs to do is point out the 10 or 15 lacunas, which are always there, and get an acquittal. The public doesn't know about it. The state is not doing anything. The state is, we would like to know from the public prosecutor, what is the mechanism to decide whether state should file an appeal against an acquittal? Is it just arbitrary without any rational criteria, or what is the basis?
Even if your lordship is page 112, here in the this is the first GD. Here it is said public suspect that Noimuddin and members of his family killed her. So there is no investigation at all in this regard. Only that this victim died within 7 years, so bring them, book them, punish them. This is the case. Nothing about this GD. Specific question is put to the IO. What happened to this GD? He said no investigation carried on. Page 112, Lordship my NDC.
Page
112. This is the first information received by police, which is also stated by PW2 himself, that he and father-in-law went there.
How is Noimuddin related with the victim?
That is not on record. And regarding the GD, specific question was put to IO Lordship. Page 41. The Lordship will find page 42, relevant portion your Lordship will find. Cross part.
Mahmoudin was arrested, your lordship. He was also arrested.
You were arrested.
41, my lord. I arrested accused Naimuddin and Karimul Islam.
Then why are you saying no, this aspect was not investigated at all, Mr. Ahmed?
Lordship, may I kindly see that page 42, Lordship.
Hmm.
Lordship, Naimuddin is the head, son of Karimul is son of Naimuddin, my lord. So
So
rightly.
he
the
was a
investigation-
co-accused.
Yes, he is the father-in-law.
No, but why is he saying no, the police has not even investigated that part? He was charge sheeted.
Yes.
So Lordship, may I kindly see page 42 cross part, Lordship. I'm reading that.
No, Naimuddin was charge sheeted. Is that not
Naimuddin,
correct?
sir.
Then why are you saying the police did not investigate? Mr. Ahmed,
Lordship, here what happened, Lordship, the
tell us.
father-in-law of the deceased and the father,
So are you saying somebody who is charge sheeted,
Lordship.
there is no investigation by the police in that matter?
So whether this is the same Noimuddin, that is not clear, Lordship. Lordship, may I kindly see that. That is why I am placing the 22, Lordship.
Lordship, my lord.
Yes, Mr. Phukan.
Lordship.
Things are continuing in the same way.
My lord.
Please tell us, in matters where there is acquittal by the trial court, whether the acquittal should be accepted by the state or not. What is the procedure that is followed before deciding to file an appeal against acquittal? On what basis these decisions are taken and what is the mechanism? Can you please tell us?
My lord, initially, when a case was a learned trial court, my lord, granted acquittal, then the said PP, my lord, written a my lord letter to the our Under Secretary Home and Political Departments
Hmm.
to file an appeal against acquittal. And thereafter, the Under Secretary Home and Political Department communicated to the PB office to file an application before the High Court against the judgment and order which is passed by the learned trial court. These are the procedures.
So if the PP conducting the trial does not make a recommendation, then it is not done.
But sometimes what happened, the said initiative was taken by the concerned police station also, my lord, where the my lord offense was, my lord, the cases was registered. The concerned SP, my lord, communicated the Under Secretary, there is a judgment has been passed by the trial court to the Under Secretary Home and Political Department. Then, my lord, Home and Political Department, either SP of the said concerned district or the PP, they send the letter to the Under Secretary Home and Political Department. They communicate to our PP. Thereafter, we can prepare an appeal file before the Supreme Court. This is the procedure. If they didn't communicate, my lord, it will, my lord, laying up there alone. No one can bother anyone.
No one bothers.
My lord, yes.
That's the bothering.
Yes.
That's the bother.
If PP and SP of the said concerned is not taking any steps, my lord, is lying out there alone. No one is bothered, my lord. Well, what happened, whoever filed this appeal, where it will go.
Is it not a matter of concern
My
then?
lord, yes, absolutely.
Hmm?
There are so many cases, my lord, granted acquittal by the learned trial court, but never we have received from the communication from the concerned department also, from the concerned learned PP from the trial court also, nor my lord SP.
Don't you think something needs to be done about it?
My lord, yes.
Who will do it?
My lord,
Hmm?
we, my lord.
Then what is stopping you?
My lord, sometimes what happened, my lord, if the learned trial court PP did not inform, my lord, in our office, then we are in hide, my lord, what is going on. If we got some newspaper and all, then only we take initiative, my lord.
That is the point. Only sensational cases the state is looking into.
My lord, yes,
But criminals are criminal, whether it is
Yes.
sensational or not,
Yes.
that doesn't matter.
absolutely.
See, we are now hearing an appeal. This is not an isolated instance. What will happen in this appeal, it's a different matter. The wife died a homicidal death under mysterious circumstances. That is established. Some witnesses have said it's a case of dowry demand, and their testimony have gone unchallenged during cross. The death took place within 3 years of marriage in mysterious circumstances. The person died an unnatural death. It's a homicidal death rather, which is established. Now, the entire family was charge sheeted along with the husband who had married the second time with another lady. Charge was framed under 304B. The IO was right in framing charge 304B, read with 302 IPC. After trial, the accused was acquitted of 302 IPC, 304B, and convicted under 302, along with accused, and there are others, other family members. The trial court does not apply 34.
My lord.
More than one person is convicted only under 302. Number one. Then the relatives of the accused persons, PW 6, 7, and 8, they are examined as prosecution witnesses. They come and introduce a new story,
My lord.
which is completely different from what the PWs 1 to 5 have introduced. For heaven's sake, one doesn't know why these people had to be examined as prosecution witnesses. Then the Lionel Trial Court acquits the main accused, which is the husband, of 304B and convicts him along with other family members under 302 IPC without 34. When we go through the records, of course, now today Mr. Ahmed has been engaged and he is arguing. We are looking at his arguments. But we find that prima facie there are enough materials to indicate that this is a clear open and shut case of 304B. But the trial court has acquitted the accused. And unless an appeal is preferred by the state, apparently suo motu can the High Court reverse the conviction or convert it into 304B. These are all legal issues, we'll
Right.
see. But assuming that it is not, then we will have to record that this is a case which clearly comes under 304B, but due to the lethargy of the state, complete breakdown of the mechanism in the prosecution department, this court is helpless and sent this order to places where it should go. What is the other option the court has?
My lord, yes. Other.
What is the other option we have?
There's no any other options, my lord.
So before, if necessary, we don't know.
Right.
He is yet to conclude. We are yet to hear Ms. Bhuya and take a final decision. But if that is the decision, what is the other option we have other than observing this?
Then, my lord, we, before passing this such
Hmm.
type of order from this court,
Hmm.
we still have take some initiative, my lord, regarding this.
No, we don't know. You tell us. You tell us what initiative? What is the change? Has anything happened in the prosecution? Is any steps taken to increase the standard of prosecution?
My lord, in some cases, I have received, my lord, from the phone calls from the public prosecutors and the SPs, my lord, regarding filing an appeal.
Hmm.
But in general, very less amounts. my lord.
No, but what is happening in this district levels? What about the PPs?
My lord, now, what happened, my lord, the PPs are, my lord, going to be changed, my lord, because director of prosecution has come. It's a discussion is going on because. there
Director
is-
prosecution has been already appointed.
Yes, my lord. Not appointed, my lord, the discussion is going on.
Hmm.
Now the process has been got, my lord, file has been ready for my lord approval. So it's very soon, my lord, these things will be happen. Then will be, my lord, is come into my lord one setup. It's almost completed, my lord, regarding the same issue, my discussion is going on. Almost in final stage, my lord. Regarding appointment of director of prosecution.
So all right, we thought we should just inform you.
My lord, yes. Of
That,
course, I will take
uh,
initiative, my lord.
We may have to make such
Much.
observations. You see what
Right.
you think is appropriate and
Right.
tell us if possible.
Lordship change. Much obliged.
Pursuing that Vidiante, it is not Normuddin, it is Moinuddin. It is wrongly typed in the type copy, Lordship. Page 112.
Yes, who? Who is the Noimuddin who has been charge sheeted?
Moinuddin is present appellant, but in the GD entry, it was mentioned as Moinuddin. That is different person, Lordship. It is your Lordship will find page 43 for a moment, Lordship.
So therefore, this person Noimuddin,
Yeah.
he has been charge sheeted, he has been subject to trial and he has been convicted,
Lordship,
correct? He is an appellant before this court.
Lordship.
You are saying the allegation that Noimuddin has killed has
No,
not been,
Moinuddin, Lordship. Initial information was that Moinuddin and Moinuddin. It is confirmed by IO. Specific question is there regarding this, Lordship. That is what I am page 43, Lordship, may kindly turn for a moment.
Hmm. Yes,
Ninth line from top, Lordship will find. It is mentioned in the GD entry that it is suspected that accused Moinuddin and his family members killed Hafiza Khatun and threw her into the water.
who is Noimuddin?
That is different person. That is what I was pressing for your Lordship. He is not brought to the into the during investigation, Lordship. His chapter is closed by the IO. Once that PW1 lost the FIR on your suspicion.
All right, you proceed, please.
And PW 6 and 7 already your Lordship has seen. PW 8 is hostile witness. PW 9, Lordship.
Lordship is written as Noimuddin.
Hmm.
Noimuddin only in the original. সন্দেহজনক আৰু নৈমুদ্দিনো তেওঁৰ পৰিয়ালৰ বৰ্গই তাইক হত্যা কৰি পানীত পেলাই দিয়া বুলি ৰাইজে সন্দেহ কৰে মতে সংবাদ পাই পঞ্জীত দৰজ দি মই নিজে ঘটনা তদন্তৰ দায়িত্ব গ্ৰহণ কৰি ঘটনাস্থলীলৈ ৰাওনা হোৱাৰ বাবে যত্নবান same person.
But in deposition, it is said Moinuddin. I have checked in original of deposition, it is also Moinuddin.
All right.
I know the accused persons about 2.5 years ago in the year 2001. One day accused Korimul came after working in our vehicle and had food in our house. Thereafter, where did accused Korimul go from our house? I do not know. But I woke up that night because it was Ramadan month and I went to Korimul's room to bring matches. Korimul sleeps on one bed of his room and accused Nurul Amin sleeps on other bed. I called Korimul as Raju and asked for a match. Then accused Korimul asked me to take matches from the room. I entered that room. Then I saw Korimul in a restless state and I guessed Korimul could not sleep that night. Accused Korimul woke up me from sleep that morning and asked for rice. After getting up from sleep, I gave rice to accused Korimul. But after eating a little, he left the rest. After some time, a boy came to my house on a bicycle and picked up Korimul on his cycle and took Korimul with him. Later, I heard that accused Korimul had killed his wife. From that day onwards, accused Korimul did not visit our house. Korimul worked as a handyman on our bus for about 15 days. I never saw Korimul's wife and never visited his house. I do not know as to how many members are there in Korimul's family, what they used to do, how they live, or how they earn their living. I do not discuss anything with the relatives of Korimul's wife. Accused Korimul used to gossip in the nearby shop after having food in our house during his stay for 15-20 days. When he used to go to the shop to gossip, we did not worry. I do not know where Korimul was gossiping after having dinner in our house at around 8 p.m. on the day of the incident, or where he went to gossip later. Sometimes Korimul goes out to gossip after eating food and coming back, he goes to sleep in the room and does not call us. On the day of the incident, accused Korimul went out after having food and I do not remember when he came back. That day around 8 p.m., I fell asleep after having dinner and cleaning the utensils. So I do not remember at what time Korimul came back that day. It was the month of Ramadan and monsoon season at the time of the incident. Next morning, when accused Korimul was sleeping, a boy from his village came and told him that his wife is ill and you have to go. Accused Korimul could not eat all served by me and went to his house after having some food. The accused Korimul was at our house on the day of the incident. I do not know how Korimul's wife died. PW10. Accused Korimul is our employee who used to work in our vehicle. The incident took place about 2.5 years ago. Around 9 p.m. on that day, accused Korimul and I were sleeping on two beds in the same room after having dinner. I do not know where Korimul went out suddenly, leaving the room that night. Later, at around 1 a.m., Korimul came back to the room. Since it was the month of Ramadan, an announcement was made from the masjid that night, and then when I opened the door, accused Korimul entered the room and fell asleep. After some time, PW9, my sister-in-law, came to the room and asked for matches. About 3 days before the incident, I saw Korimul in a restless state. He had stopped eating properly. The next day, a man came to Korimul and informed him that his Korimul's wife was ill. Then he went home after having meal. The same day, I heard that the wife of the accused Korimul had died. I heard that wife of Korimul was thrown into the pond by tying a pot around her neck. The police examined me. Cross. I had not seen Korimul's wife before. I do not know how the married life of Korimul and his wife was. There was no discussion with the family members of Korimul's wife regarding this incident. I do not know how many members are there in Korimul's family, and I do not know anything about his father, mother, and others. I do not know anything as to where did accused Korimul go after having dinner that night and what he did. Accused Korimul sometimes went out after having food at night. I did not ask Korimul why he was in restless condition 3 days before the incident. That day around 1 a.m., when accused Korimul knocked on the door, I opened the door. It is not a fact that while giving a statement to police, I said that I kept the door open so that accused Korimul could come to sleep. I did not
Yes,
state-
Mr. Ahmed will continue. Okay, you finish this, yes.
I did not state to police that accused Korimul's wife was thrown into the pond by tying a pot around her neck. The police came to our house after 1 day of the incident to interrogate about the incident. I did not see how the wife of accused Korimul died. I do not know anything about the family life of Korimul. 12, Lordship. Ayo,
Ayo.
page 41. On 28/8/2009, I was working as IC in the Kolgasia outpost. At 6:15 a.m. That day, Abdul Kasem and BDP Secretary of Monakasa village informed me over mobile phone that around 12 a.m., daughter-in-law of Muhammad Noimuddin died in the pond at his house. On getting the information that the death of the daughter-in-law, Hafiza Khatun, is suspicious and Noimuddin and his family members killed her and threw her into the water. The entry has been made by GD entry number 494 dated 28/9/2009 and I personally visited the place of occurrence. I examined the witnesses and recorded their statements. I got the inquest held by a magistrate on the dead body of the deceased, and the report was collected after conducting the postmortem During investigation, the same day, I arrested accused Normuddin and Karimul Islam and sent them to the court. Later on, 29/8/2009, Saiful Islam, paternal uncle of Hafiza Khatun, lodged an Azahar. The Azahar was forwarded to Sorbok police station to register the case. I drew the sketch map of the place of occurrence. Exhibit 4 is the GD entry. Exhibit 4.1 is my signature. Exhibit 5 is the sketch map. Exhibit 5.1 is my signature. During the investigation, other accused persons surrendered in the court. After completing the investigation on 25/10/2009, I have submitted the charge sheet under section 498(a)(304)B/34 IPC against the 7 accused persons mentioned in the Azahar. Exhibit 6 is the charge sheet and Exhibit 6.1 is my signature. I collected the postmortem report, cross indifferent. The GD entry number 494 dated 28/8/2009, which I have submitted along with the case, was copied from GD entry register. In this copy, the GD entry compared with the original is not mentioned. The said register of GD entry was not brought in the court today. On the basis of the GD entry, the investigation was started. This copy of GD entry was the copy of first information. Around 6:20 a.m., I opened the case diary. Around 6:30 a.m., I left for the place of occurrence, and around 7 a.m., I reached the place of occurrence. I prepared inquest report on the basis of GD entry. This GD entry was mentioned as GD entry number 495 dated 28/8/2009. The inquest report and the GD entry were not seen with the case. On 28/9/2009, I got the Azahar. On the basis of the Azahar, GD entry number 503 dated 28/8/2009 was registered. Around 2 p.m., I got the Azahar in the outpost. I do not remember whether the GD entry number 494 dated 28/8/2009 was sent or made it seen by the learned magistrate. But document reveals that the copy of the said GD entry was sent along with the Azahar. I did not mention separately that the copy of the GD entry was enclosed with the charge sheet. It is mentioned in the GD entry that it is suspected that accused Moinuddin and his family members killed Hafiza Khatun and threw her into the water. Accused Usman Ali is relative of accused Karimul. Accused Nur Hussain, Arman Ali, Usman Ali, and Surman are relative of Karimul. How the 4 accused persons were related to Karimul was not mentioned in my case diary. In the Azahar, it was mentioned that accused number 1 got married for the second time on the ill advice of accused number 2, 3, 4, 5, 6, and 7. No case was lodged regarding the second marriage. It is not mentioned in the case diary of Kolgasia police station that accused number 1, Karimul, got married for the second time without taking permission from his first wife. But it is written in my case diary that after going to Guwahati, accused Karimul got married for the second time. I did not collect the name of the second wife. It is not mentioned in my case diary that on which date of which year the accused persons demanded dowry from the deceased Hafiza. This is relevant, Lordship. It is not mentioned in my case diary that on which date of which year the accused persons demanded dowry from deceased Hafiza. I did not investigate in Serbok police station if deceased Hafiza had filed any case regarding dowry in the last 3 years. I did not inquire whether any extrajudicial trial had taken place in his village prior to this incident. I recorded the statements of people living near the place of occurrence. I recorded the statement of PW1, Saiful Islam Bhuya, in the police station after the Azahar was lodged. It is not mentioned as at what time I recorded the statement. The PW1 did not tell me that 2 persons came at night and told him that Hafiza's daughter had died. The same witness did not tell that he witnessed injury in her person and neck, and that he witnessed blood oozing out. PW1 did not tell that he did not meet anyone when he went to Hafiza's house or that they had played away. He told that he suspected that the accused persons had killed Hafiza. I did not record the statement of any person named Khalilur Rahman. PW2 Abdul Rahman Bhuya did not state before me that he gave 25 mounts paddy to the accused while Hafiza was alive. This witness did not state that he saw mark of pressing on the neck, on her neck and her upper part of arm. But he told me that he had seen black injury mark on Hafiza's neck. PW3 Mubarak Ali did not tell me in his statement that after coming home 2 weeks before the incident, the girl said that she was assaulted for dowry. This witness did not tell me that accused Noimuddin went to bring Hafiza, that Noimuddin was told that Karimul had got married for the second time, that Hafiza was sent with her father-in-law, and that Kamela Hatun was sitting near the dead body of Hafiza. PW5 Kamala did not tell me in her statement that Hafiza was sent to their house for money. PW5 Ankomola told me that accused Karimul married another woman in Guwahati. In the morning, the news of the death of her daughter at her husband's house was received. PW5 did not tell me in her statement that she witnessed injury mark on Hafiza's both arms and neck, and that there was no hair on the backside of her head. PW5 did not tell me that the bed and the table chair were in a messy state inside Hafiza's room. PW10 Nurul Amin did not tell me that accused Karimul threw Hafiza into the pond by tying a pot around her neck. Page 45. No prior case was lodged by the parties before the case in hand. I did not find any specific date on which dowry was demanded during my investigation.
Yes.
PW13 is circle officer who conducted the inquest. On 28/8/2009, I was working as circle officer, Kolgasia Revenue Circle, Kolgasia, and on that day, on police requisition, in reference to Kolgasia OP GD number 495 dated 28/8/2009, I visited Monacosa and performed inquest over the dead body of Hafiza Khatun, wife of Karimul Islam, village so-and-so. Exhibit 2 is the inquest report. Cross. I prepared the inquest report on the basis of GD entry number 495 dated 28/8/2009. The inquest report was written by SI of police as per my instruction, but there is no signature of the SI who written the inquest report. I cannot say the name of the SI in the inquest report. The place of occurrence has not mentioned specifically. I know the medical officer. He is the medical superintendent, deputy superintendent of Fakhruddin Ali Ahmed Medical College Hospital also. I know medical officer GC Medhi who performed postmortem examination on the dead body of Hafiza Khatun. Cross. The weapon by which injury was caused is not mentioned in the postmortem report. This type of head injury may be caused by dashing on stone if the depth of water is low. In some cases, due to head injury, bleeding may occur through nose and ears, but not in all cases. This is contradictory to what earlier doctor said. In the postmortem report, it is not mentioned whether the injury number 4 is grievous or simple. The age and time of the injuries are not mentioned. The name of neither the father nor the husband of the deceased is mentioned in the PM report. Generally, the name of husband or father is mentioned in the report. I cannot say the exact time of death by going to the PM report. So this is the evidence that is by the prosecution side. And
See, page 47 is continuation of page 40. Okay, MGC meeting.
Hmm.
No?
all the witnesses were second time examined because 302 was added subsequently. So the witnesses were again cross-examined.
All right.
This is the evidence on record. From the evidence, Lordship, what I find, Lordship, subject to correction, that there is no material to connect the appellant under section for the offense under section 302 as held by learned trial court, Lordship. And circumstances which is relied on by the court below is not sufficient to convict the appellants under section 302. And 304B already they were acquitted. Although I have submitted one judgment. Apart from that, Lordship, from the materials on record, it does not show that the ingredients necessary to convict a person under section 304B is fulfilled here, Lordship.
What are the ingredients?
Ingredients are, Lordship, that first homicidal death that is there, that she was subjected to torture in connection with the demand of dowry. That has to be there. But here, demand of dowry is, say, a few witnesses say, but that are also in regard to some business loss, not a other purpose. So even if we assume that.
Just a minute. Let us. Let's come to page 17
Lordship.
and line about 13 from the top, in the middle of the several meetings of extrajudicial settlement.
Yes.
Can you read it?
Several meetings of for extrajudicial settlement were held in our village regarding the demand of money made to Hafiza by the accused, and Headmaster Khalilur Rahman remained present in one of such meetings. Headmaster Khalilur Rahman knows well about the demand of money made to Hafiza by the accused persons. So my submission for Lordship is
1 minute, there are more.
Lordship.
Then come to page 16,
Lordship.
line about 5 from the top, accused Karimul.
Yes. Accused Korimul and his father Noimuddin had been torturing my daughter a lot since after her marriage in demand of dowry.
This evidence, there is no challenge in the cross-examination.
So here your Lordship will see that after that line, Lordship, accused Korimul and his father Noimuddin had been torturing my daughter a lot since after her marriage in demand of dowry. I am a chowkidar in a school and I fulfill the demands of the accused person by giving them money occasionally. So those demands were fulfilled. Here the death they have to prove that in connection with demand of dowry, this incident occurred. Not to
Nothing.
the accident.
Who says it has to be proved?
Lordship, I will place.
This is straight and forward. He is saying that there were demands and tortures.
Lordship,
Tortures and demand.
Lordship,
I fulfill some of the demands.
Lordship.
So this is an indication that what the witness is saying, that his daughter used to be tortured in connection with demand of money,
Lordship.
and sometimes occasionally he used to fulfill it. Occasionally, the word used is occasionally.
But in, at the same time, your lordship will kindly say that PW5 said that since 9 months back from the date of incident, the deceased was residing with him. So this incident occurred prior to 9 months of the incident. Page 25, your lordship may kindly see.
Hmm.
Page 25.
Hmm.
Last 4 line I'm reading. Then I again gave her some amount of money and sent her back. In the meantime, accused Korimul went to Guwahati and he got married for the second time and came back home with her. This time Hafiza came to my house and said that since Korimul got married for the second time and brought his second wife home, she would not go there again. That time Hafiza stayed in my house for 9 months. So those demands were prior to 9 months, but not soon before the date.
We'll hear him.
Not soon before the date.
No, of that paragraph, last few lines, page 26. The accused person harassed her, demanding money and killed her.
But incidentally, this testimony of these witnesses,
Lordship,
including PW5,
Lordship.
those have not been assailed in the cross-examination. That's what we find.
But my understanding is that, Lordship, there has to be some proximity with the demand of dowry and torture with the death, Lordship.
So
But what-
you agree to this, that these evidence, oral evidence coming from the parents of the
Lordship,
victim
Lordship.
have remained unassailed during the cross-examination. Do you agree with that?
This part, Lordship, some witnesses did not state before once in 161.
We are
That I have
talking about
pointed out.
these witnesses, including PW5. Some witnesses will come to it later. See, these
Yeah.
criminal proceedings are technical.
Lordship,
Technicalities will work both ways.
Lordship.
No evidence, acquittal. But
Right.
if evidence is there unimpeached, that will be acted upon by the
Right.
court. There you can't take the plea that my lawyer didn't know to consent. That you can't. Because then the state will say the prosecutor did not
Yeah.
know. So it will work both ways.
Lordship.
This is an unimpeached piece of evidence. Do you agree with that?
Yes, Lordship. But here your Lordship will have to see, Lordship, in my understanding, Lordship, that there is no specific time or date. Nothing has been mentioned. While allegation is that the accused person harassed her, demanding money and killed her. When the demand was made, when how much demand was made, to whom it was made, nothing has been mentioned.
That you convince us that these things have to be established by
Yes, yes.
relying on decisions.
Yes, I'm relying on decision of 2014 9 SCC, Lordship.
Hmm.
2014 9 SCC, I have given her. Six, four, five. Manohar Lal. The paragraph 17 and 18, Lordship.
Yes.
Section 304B IPC relates to dowry debt and reads as follows. 304B dowry debt, where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage. And it is shown that soon before her death, she was subjected to cruelty and harassment by her husband or any relative of her husband for or in connection with any demand for dowry. Such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. Explanation: for the purpose of subsection dowry shall have the same meaning as in section 2 of the Dowry Prohibition Act 1961. Number 2, whoever commits dowry debt shall be punished with imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life. Paragraph 18. For the purpose of the said section, a presumption can be raised only on proof of following essentials. A. Death of the woman was caused by burns or bodily injury or occurs otherwise than under normal circumstances. Such death took place within 7 years of her marriage. The woman was subjected to cruelty or harassment by her husband or his relatives. Such cruelty or harassment was for or in connection with any demand for such dowry, and such cruelty or harassment was soon before her death. In this connection, we may refer to decision of so and so. So these 5 ingredients has to be proved before the presumption can be raised. And now your lordship will kindly see 2004 13 SCC. 2004 13 SCC, page 300. Here it is discussed about soon before that part. Paragraph 18. Our attention was drawn to section 113B of the Evidence Act and section 304B of the Indian Penal Code by the learned counsel appearing for the accused. A conjoint reading of section 113B of the Indian Evidence Act and section 304B of the Indian Penal Code shows that there must be material to show that soon before her death, the victim was subjected to cruelty or harassment. The prosecution has to rule out the possibility of a natural or accidental death so as to bring it within the purview of death occurring otherwise than in normal circumstances. For the above proposition, the learned counsel appearing for the accused cited the judgment of this court in the case Hiralal versus State Govt of Delhi. In that case, this court observed thus: the expression soon before is very relevant where section 113B of the Evidence Act and section 304B IPC are placed into service. The prosecution is obliged to show that soon before the occurrence there was cruelty or harassment, and only in that case presumption operates. Evidence in that regard has to be laid by the prosecution. Soon before is a relative term and it would depend upon the circumstances of each case, and no straitjacket formula can be laid down as to what would constitute a period of soon before the occurrence. It would be hazardous to indicate any fixed period, and that brings in the importance of a proximity test both for the proof of an offense of dowry death as well as for raising a presumption under section 113B of the Evidence Act. The expression soon before her death used in the substantive section 304B IPC and section 113B of the Evidence Act is present, and the idea of proximity test, no definite period has been indicated and the expression soon before is not defined. A reference to the expression soon before used in section 114 illustration A of the Evidence Act is relevant. It lays down that a court may presume that a man who is in possession of goods.
Yes.
It lays down that a court may presume that a man who is in the possession of goods soon after the theft is either the thief or has received the goods knowing them to be stolen, unless he can account for their possession. The determination of the period which can come within the term soon before is left to be determined by the court depending upon facts and circumstances of each case. Suffice, however, to indicate that the expression soon before would normally imply that the interval should not be much between the cruelty or harassment concerned and the death in question. there must be existence of a proximate and live link between the effect of cruelty based on dowry demand and the death concern. If the alleged incident of cruelty is remote in time and has become stalled enough not to disturb the mental equilibrium of the woman concerned, it would be of no consequence. Here also what I have placed before Lordship that PW file had clearly said that since last 9 months, the victim was residing in his house. So since 9 months, there was no demand or torture, that part. And next Lordship, 2007 9 SCC.
Yes.
2007 9 SCC 721. Paragraph 9, 10, and 11. Lordship. Here dowry is defined. What kind of articles will be
9, 10, and 11.
Lordship?
Yes.
Two essential ingredients of section 304B IPC, apart from others, are death of woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances, and woman is subjected to cruelty or harassment by her husband or relative of her husband for or in connection with any demand of dowry. The expression appended to section 1 of section 304B IPC says that dowry shall have the same meaning as in section 2 of the Dowry Prohibition Act 1961. Section 2 of the Dowry Prohibition Act reads as under 2. Definition of dowry. In this act, dowry means any property or valuable security given or agreed to be given either directly or indirectly.
No, all right, you can skip the definition. We have
Lordship.
read it.
Paragraph 11. In view of the aforesaid definition of the word dowry, any property or valuable security should be given or agreed to be given either directly or indirectly, or at or before or any time after the marriage and in connection with the marriage of the said parties. Therefore, the giving or taking of property or valuable security must have some connection with the marriage of the parties, and a correlation between the giving or taking of property or value security with the marriage of the parties is essential. Being a penal provision, it has to be strictly construed. Dowry is a fairly well-known social custom or practice in India. It is well settled principle of interpretation of statute that if the act is passed with reference to a particular trade, business, or transaction, and words are used which everybody conversant with the trade, business, or transaction knows or understood to have a particular meaning in it, then the words are to be construed as having that particular meaning. A demand for money on account of some financial stringency, or for meeting some urgent domestic expenses, or for purchasing manure cannot be termed as a demand for dowry as the said word is normally understood. The evidence adduced by the prosecution does not therefore show that any demand of dowry as defined under section 2 of the Dowry Prohibition Act was made by the appellants, as what was allegedly asked for was some money for meeting domestic expenses and for purchasing manure. Since an essential ingredient of section 304B IPC that demand for dowry is not established, the conviction of the appellants cannot be sustained. Here also that the specific amount which was mentioned, they have clarified in cross-examination that those were given for business purpose. So that it will not come in the purview of dowry lordship. And apart from that, there is no specific allegation when money was demanded, how much money was demanded, nothing on record. Another judgment, single bench judgment, although but here some Supreme Court judgments are cited. Therefore, I'm placing for your lordship. 2008 1 GLT 446. From paragraph 11 onwards, Lordship, dowry is explained here. Various judgments of Honorable Apex Court discussed.
Yes, which paragraph?
From paragraph 11 onwards, Lordship.
Yes, let us read it.
To appreciate the argument of the parties, it would be proper for this court to firstly consider that what is the meaning of cruelty and dowry. Cruelty by expression A and B of 498A IPC, cruelty has been defined as follows. A, willful conduct, so I am skipping that. Dowry. Dowry dos moliras lat, otherwise called meritagam or marriage goods, that which the wife brings to the husband in marriage. This word should not be founded with dower. Lit. Wharton's law lexicon. The definition of dowry will also be available in section 2 of the Dowry Prohibition Act 1961. In common parlance, dowry means where the husband or his relations demand valuable security from the parents and other relations of the wife after the marriage. In para number 11, 12, and 13 of the case of Bikram Singh, Rajasthan reported, so in Sadbir Singh versus State of Punjab, so the Honorable Apex Court considered and the definition of dowry as defined under section 2 of the Dowry Prohibition Act with reference to the offense under section 304B of IPC, and held that it should be any property or valuable security given or agreed to be given in connection with marriage, customary gift or payment in connection with birth of child or other ceremonies unrelated to marriage ceremony held do not fall within the ambit of dowry. The relevant para 21 of the judgment reads as under. Thus, there are 3 occasions related to dowry. One is before the marriage, second is at the time of marriage, after the marriage. The third occasion may appear to be an unending period, but crucial work are in connection with the marriage of the said parties. This means that giving or agreeing to give any property or valuable security on any of the above 3 stages should have been in connection with the marriage of the parties. There can be many other instances for payment of money or giving property as between the spouses. For example, some customary payments in connection with birth of a child or other ceremonies are prevalent in different societies. Such payments are not enveloped within the ambit of dowry. Hence, the dowry mentioned in section 304B should be any property or valuable security given or agreed to be given in connection with the marriage. In HK Prema S. Rao versus Yadla Srinivasa Rao, the Honorable Apex Court considered the definition of dowry in the context of offense under section 304. It should have been B, along with section 113B of the Evidence Act, and held that one of the key ingredients of the offense is that deceased must have been subjected to cruelty and harassment in connection with the demand of dowry. And in connection with the demand of dowry shortly before her death. Para 16 of the judgment reads as under. The evidence which has been found acceptable by the courts below against accused number 1 is that the cruel treatment and harassment of the deceased by him led her to commit suicide, which was a death otherwise than under normal circumstances. To attract the provision of section 304B IPC, one of the main ingredients of the offense which is required to be established is that Soon before her death, she was subjected to cruelty and harassment in connection with the demand of dowry. There is no evidence on record to show that land was demanded as dowry. It was given by the father of the deceased in marriage ritual as Puspa Pasupu Kumkuma. The harassment or cruelty meted out to the deceased by the husband after the marriage to force her to transfer the land in his name was not in connection with any demand for dowry. One of the main ingredients of the offense for demand of dowry being absent in this case, the High Court cannot be said to have committed any error in acquitting the accused number 1 for the offense under section 304B IPC. And next paragraph, Lordship, in Appa Saheb and another, their Lordship of the Honorable Supreme Court considered the similar point in the context of the offense under section 304B IPC with the meaning of dowry as defined under section 2 of the Dowry Prohibition Act and held that giving or taking of property or valuable security must have some connection with the marriage of the party and a correlation between the giving or taking of property or valuable security with the marriage of the parties is essential. A demand for money on account of some financial stringency or for meeting for some urgent domestic expenses or for purchasing manure cannot be termed as a demand for dowry as the said word is normally understood. That judgment I have already placed before your Lordship.
Yes.
Here also another judgment, Lordship, 2004 3 SCC 199. Paragraph 13, 14, 15, and 16. I'm just reading paragraph 16, last 5 paragraphs, Lordship.
Paragraph 15.
Paragraph 16, last 5 paragraph.
16, last 5 paragraph means
Last 5 paragraph of paragraph 16. Line, fifth line of
actually, last 5 lines of para
Lots,
16.
lots of
Oh, you are saying last 5 paragraphs of para 16.
I'm sorry.
Hmm.
Thus voluntarily presents given at or before or after the marriage to the bride or the bridegroom as the case may be, or a traditional nature which are given not as a consideration for marriage but out of love, affection or regard would not fall within the mischief of the expression dowry made punishable under the Dowry Act. So here also the PWP said that he had love and affection, those things are there, Lordship. And the money which was given initially, that was for business purpose, which PWP admitted. Lordship. Just page 18, your Lordship will find.
The business purpose means he was employed under someone. He was a handyman.
No, he was not financially sound. That is what PW2 said. That is why I'm page 18, your Lordship will find.
No, Mr. Ahmed, as you argue your cases, we have taken note of these decisions. These are judgments of the Supreme Court. These will be binding. There is no question of taking a view which is in conflict with any of these judgments. But having said that, the Supreme Court has said that this expression soon before a death is not a defined expression.
Lordship.
It is to be distinguished and differentiated from the expression immediately before the death.
Lordship.
The expression is not immediately before the death.
Yeah.
What would be soon before the death is obviously something which has to be understood in the facts and circumstances of the case. You please address the court on this point that we have seen the father and mother of the vessel saying that 34,000 and bangles, etc., ornaments were given at the time of marriage.
No,
Correct.
Lordship.
That is one part. Then there is evidence that after the marriage also, there were repeated demands of dowry, of money. And the father said, I occasionally paid it.
Lordship.
And there is evidence to show that there were village vichars on this.
Lordship.
What is the dispute? The accused, number one, wanted money and he used to torture the wife, for which she used to come home. And then suddenly he got married to another lady. Now, if she came back home, these are rural people, they are not sophisticated, literate people like this.
Yes.
So they say that there was demand for money and they killed. The date is not mentioned. I have said that they have not told me when and in what manner the demand was made. But this evidence of the father and mother of the victim has also not been challenged by the defense side. So what remains unimpeached is that there was demand for money leading to her death. So if there was a demand for money for which she had to leave the matrimonial home, after she went back, soon thereafter there was a death. Why should he not construe that this period during which she was with her in her parental home, that period would be of no significance, because after her return, then the incident happened and she came to a parental home because of the torture meted out in connection with dowry. So this 9 months benefit will not go to the accused.
So here, Lordship, just one thing I'm placing for your Lordship is that when she left the house, that was not for the demand of dowry, because the accused remarried. For that purpose, she left. And secondly, Lordship, when she came back, father also said that the father-in-law of the deceased took her from her house. And thereafter, there was no demand, as per evidence of PW2. At that point of time also, there was no demand. It was only after, prior to 9 months, when he remarried prior to that. After that, there is no incident. Just
You take note of this and please address us. Yes.
So I'm placing that. Another aspect, Lordship, PW2 also admit that I was not forced to give the materials and money at the time of marriage. So there was no force. That part also there. It's 15 days prior to the occurrence, page 18, Lordship.
Page 18.
Yes, Lordship. 9th line from top, Lordship. Page 18.
Hmm.
15 days prior to the occurrence, accused Korimul came to my house and brought Hafiza from my house. That day, accused Korimul denied in our house.
Not denied, dying.
Died. Sorry. Dined in our house. Sorry. That day, accused Korimul dined in our house. Accused Korimul quarreled with me and my wife. Then Hafiza told us that she would go to her husband's house and would come back after some days. After Hafiza's departure from my house that day, I did not make any inquiry about her. So during that period also no demand also. Or neither allegation about any torture. And from the evidence of PW5, it also I have shown that she left the house because of second marriage, not due to torture, Lordship. PW5 says, Lordship, that I am placing again before your Lordship. Page 25, your Lordship will find that part.
Yes.
Page 25. Last 3 lines. In the meantime, accused Korimul went to Guwahati and he got married for second time and came back home with her. This time Hafiza came to my house and said that since Korimul got married for the second time and brought his second wife home, she would not go there again. That time Hafiza stayed in my house for 9 months. So she went because of the second marriage and stayed there for 9 months. So during this period, there is no allegation that she was tortured or dowry was demanded.
Yes.
So my submission to your lordship is that even though they stated that accused person harassed her, demanding money and killed her. That statement do not point out any specific lordship allegation is there any specifically when the demand was made, because to attract section 304B there has to be direct proximity between demand and torture, lordship, in connection with the death. Here that connection is missing, lordship. Because from the evidence of PW5, it is clear that she left the house because of second marriage. Subsequently, she again came. And for PW2 also said that during this 15 days period, no demand was made. So there is no direct connection between the demand and her death, lordship. This is a homicidal death and prosecution failed to prove who caused the this homicidal death, lordship. This is my humble submission, lordship.
All right.
And that judgment also regarding
What is this judgment? Which
acquitted.
part you want to rely upon?
Paragraph 28, lordship. Nur Mohammed, lordship.
Paragraph
Paragraph 28. May I read, lordship?
28.
28.
Yes.
Evidence on record reveals that deceased has committed suicide by hanging at her matrimonial home within a period of 2 years of her marriage. It is well as settled that death due to suicide also falls within the category of death otherwise than under normal circumstances, as mentioned in section 304B IPC. All the witnesses of fact have categorically deposed that deceased was continuously harassed for dowry and she was brought to her matrimonial only 1 week before of incident. There is also cogent and categorical evidence that accused and his family members used to demand golden chain, motorcycle, and cash of rupees 1 lakh from deceased, and on that account she was harassed by the accused persons by learned trial court. But the learned trial court has acquitted accused appellant as well as co-accused persons of the charge under section 498A 304B IPC and 34 of Dowry Prohibition Act. As no appeal has been preferred against acquittal of accused appellant under section 498A 304B IPC and 34 of Dowry Prohibition Act, and thus this court cannot alter conviction from under section 302 IPC 2 under section 304B 498A and 34 of DP Act. Here it would be relevant to mention that in case reported as 2001 to SCC 577, Samsaheb M. Multani versus State of Karnataka, a 3-judge bench noted that where main ingredients of 2 cogent offenses are common, the one punishable with lesser sentence can be said to be minor offense. Nothing that the ingredients of section 304B IPC were different from those of section 302 IPC. The former could not be regarded as minor offense of the latter, and it was held as under. In such a situation, if the trial court finds that the prosecution has failed to make out the case under section 302 IPC, but the offense under section 304B IPC has been made out. The court has to call upon the accused to enter on his defense in respect of the said offense. Without affording such an opportunity to the accused, a conviction under section 304B IPC would lead to real and serious miscarriage of justice. Even if no such count was included in the charge, when the court affords him an opportunity to discharge his burden by putting him to notice regarding the prima facie view of the court, and he is liable to be convicted under section 304B IPC. Unless he succeeds in disproving the presumption, it is possible for the court to enter upon a conviction of the said offense in the event of his failure to disprove the presumption. In view of the above discussion position of law, it is not possible to convert conviction of the accused appellant from section 302 IPC to section 304B, 498 IPC and section 334 DP Act, particularly when no appeal has been filed against acquittal of accused appellant under section 304B, 498A IPC and section 34 DP Act. The case of Girish Singh, so referred by learned counsel for appellant, so this is not relevant also. This is my humble submission.
I do have two, your lordship.
Acha, can you get hold of this judgment? 2001 to SCC 577. SHAMNSAHEB Shamansad M. Multani versus State of Karnataka. Please go through this judgment also.
I've got one Supreme Court judgment of Constitutional Bench. That is defined soon before the date. It's April 2022. I've passed my.
You can give her the citation.
Yes.
also. All right, then item 6. Yes, who you are there?
Yes, Lordship.
Why pass over?
Actually, the Lordship, senior is, due to some emergency, he has left the court.
Oh,
Any other day, Lordship?
Oh, I cannot consent to that, but it's up to your lordship.
you wait, we'll see.
Obvious, Lordship.
Yes, please.
Lordship.
Mr. Das. Then you have it after 2 weeks. You will have also be stuck up here. Item 6. A prayer for adjournment has been made on behalf of the appellant on the ground that who is your senior?
Well, P. Katoki.
Mr. P. Kotaki, learned arguing counsel, had to leave the court premises due to some personal reasons. Mr. D.K. Das, learned senior counsel, assisted by
Sir,
PK.
P. K. Darji.
P.K. Darji, is present on behalf of the respondent. In view of the prayer made by the appellant's counsel, we adjourn the hearing of this appeal by 2 weeks. Let the matter be listed accordingly.
Obvious, Lordship. Lordship made pieces. In the case in hand, your Lordship, PW1, PW2, PW1 is the uncle of the victim, PW2, the father of the victim,
PW3, who is also another uncle. And other 11 witnesses have lordship elaborately, this lordship, they have deposed that there is sufficient material against the accused persons, my lord, to charge them under section 304B as well as 302, your lordship. Although your lordship 304B charges were lordship, they were acquitted from the charges, but lordship 302 was upheld by the learned trial court, your lordship. May I take your lordship whether there was a demand for dowry from the inception, from the marriage and thereafter? Lordship, evidence of PW1, my lord.
Yes.
Yes, page 10, my lord. I know the accused persons at about 3 AM on 24/4/07, the incident took place. And it was a fasting day of Ramadan. We had our meal at 3 AM. At that time, two persons came to my residence and informed that Kahinoor, the daughter of my nephew Hafiza, had died. Hearing the information, I sent my elder brother Abdul Rahim Bhuya and my sister-in-law Ankamala to the residence of Hafiz. On reaching there, they saw that Hafiza had died. Our daughter did not die. When my elder brother informed me, I immediately went there and saw that Hafiza was lying dead on the bank of the pond near her residence. I saw injury mark on Hafiza's neck and her person. Moreover, I saw that the blood was oozing out. As a first circumstance, as regards dowry, that your lordship 304B.
Ms.
That-
Bhuya, just a minute,
My
we
lord.
are just interrupting. You see, 304B, the appellant has been acquitted, appellants.
Yes.
That's the point which was troubling us when we left the other day. In a case of acquittal, the court cannot convict them under 304B unless there is an appeal preferred against acquittal. So perhaps it will not be possible to go into that aspect. 304B is there or not, we can't now go into it. Suddenly, we can't convert an acquittal into a conviction.
Conviction.
Insofar as 302 IPC is concerned, we have already raised this issue that
34 is.
there is 34 has not been, there is no finding about common intention. Then whether through circumstantial evidence, whether the murder of the deceased has been proved or not, that is the only thing we have to see here. Looks very difficult for the state.
Lordship, may I take your lordship? 386 of the CRPC, your lordship,
Section
386, my lord,
386.
power of the appellate court.
Yes.
After perusing such record and hearing the appellant or his pleader, if he appears and public prosecutor and the public prosecutor, if he appears, in case of an appeal under section 378 or 377 or 378, the accused, if he appears, the appellate court may, if it considers that there is no sufficient ground for interfering.
You're
with
reading
this
section 380,
86.
386.
Yes, powers of the appellate court.
Yes.
Lordship, if our case is under appeal under conviction, my lord. An appeal from an order of acquittal, reverse such order and direct that further inquiry be made, because in this case, no order against acquittal is there. In an appeal from a conviction, reverse the finding and sentence and acquit or discharge the accused or order him to be retried by court of competent jurisdiction subordinate to such appellate court or committed for trial. Alter the finding, maintaining the sentence. With or without altering the finding, alter the nature or the extent or the nature and extent of the sentence, but not so as to enhance the same. In an appeal for enhancement of sentence, there is nothing as such, my lord. So your lordship may, I think under the appellate jurisdiction also, your lordship may do so. Although there is no appeal against acquittal.
How can a order of acquittal, suo moto, the court will convert it into conviction? How can it be done? Because we are not prosecuting, the state is prosecuting.
Yes.
The court is not prosecuting.
Yes.
We are only to see whether the
Lordship, after
conviction.
giving evidence, Lordship, in elaborately giving the details, your Lordship may come
No,
to a
no, Miss
finding.
Oya, please understand
My
the
lord.
scheme.
My lord,
The role of the court is only to see whether the charge has been proved or not.
yes.
The role of the court is not to see who should have been prosecuted and who should have been convicted. That's not the role of the court. So right now before us, they are in appeal against the conviction awarded under 302 of the IPC. We are only to see whether that conviction is
Sustains or not.
sustainable or not. We are not here to recommend that instead of this, you should do this,
Mhm.
you should prefer an appeal. On a larger spectrum of public interest, the courts may sometimes express anguish. But if the state, if we write in our judgment, it will be on record. The state doesn't want to challenge the order. The High Court is challenging the order of the trial court. That is how it will turn out to be. We will not do that. That's not permissible.
Lordship, may I find out some judgments in that regard, whether after acquitting the accused person, can the appellate court appeal against conviction can still interfere into it, your Lordship? And your Lordship asked me to go through the judgment, your Lordship, Devendra Singh, not the Devendra Singh, the other one. Shama Sahib Multani, here the charge was not framed. In our case, charges were framed under 304B as well as under 302. In this case, I may be wrong, your Lordship, charges were not framed. So
That
yes,
you are right.
yes.
You're right. Here charges were framed, the evidence is there.
Yes,
He cannot say that, they cannot say that we did not need evidence. But the point is, there is an order of acquittal.
yes. So in that case, whether appellate court against the order of conviction can interfere into the order of acquittal, which is already passed by the
At whose
learned trial.
instance?
Yes,
At whose instance?
yes.
At whose instance?
Yes, your Lordship, that aspect, can I go into it? May I be given an opportunity so that I can find some judgments, at least maybe taken up day after tomorrow? It's a Thursday.
Thursday. See, otherwise, things look very tight. See, something has happened. The lady, the victim has died a homicidal death. There are medical reports. And then it happened in the matrimonial house. There is no explanation. There are evidences that some demand was there, dowry demand. He says it is not in close proximity. That is a matter of interpretation. One has to call out the expression, a meaning of the expression, and give it due interpretation based on the facts of the case. But why should we undertake that exercise unless we know that suo motu the court has the power to
Yes,
convert an order of acquittal
Acquittal
into
to-
one
yes.
of conviction? That does not appear to be the scheme of CRPC. If that is not there, we will not do it. That would leave us with only with the sole issue as to whether the charge under 302 of the IPC is proved. Here, things are very cut and dry. You are convicting, how many appellants are here?
here,
Three. Three appellants cannot be convicted without 34. 34 means you have to show the common
common
intent.
intention.
Otherwise, all of them will have to be acquitted. So 302, unless the court records a finding as to which of the accused person has specifically committed it, which is not possible. So this is a case of acquittal. It is yet another demonstration of the poor state of affairs at the investigation and trial level. What option do we have? We will observe these things, and giving you 2 days' time is not a problem, but what is that you can do in 2 days' time? The fact of the matter is the state does not give any importance to investigation and prosecution. If some changes are happening in these days, we don't know. We don't know what is happening. But nothing is visible. Nothing is visible. So this is the state of affairs, and It's no wonder the conviction rate is about 12% or something. It should be 0.1%. Forcefully, the sessions courts are giving conviction. Otherwise, there is nothing in the investigation, nothing. The IOs, it is not that they are corrupt in all cases. They just don't know, and there is no one to tell them. They don't have the training, they don't have the knowledge. After tomorrow, we'll close it. Heard Mr. A. Ahmed, learned counsel for the appellant, also heard Ms. B. Here, learned APP Assam appearing for the state full place, but posting this matter again on 1/12/2022 for further hearing, so as to enable her to examine certain subtle legal issues and address this code. They are allowed registry to list the matter again on 1/12/2022 as a fixed parted matter.
Soon before the death, the definition, I found one judgment, my lordship, the student sitting there, he gave me. It's really.
Yes, come forward, please. You are from which law college? All right,
So nice of him, he just.
so you are following this matter?
Yes, sir.
Have you understood what is happening?
Indeed, your lordship.
What, would you like to say anything?
Definitely, sir, this is there's a fallacy of law, I guess,
Hmm.
because on the prosecution side, they have already prosecuted, cross-examined the witnesses which is in support of the defense, sir.
That's correct.
Yes, sir.
Hmm. So they have, what is your name, first of all?
Krishnav Kokham Gogoi.
Krishna?
Krishnav Kokham Gogoi.
Krishna Gogoi. You are doing your law graduation
Yes, 5-year integrated course. I am in third sem.
in Symbiosis.
Embassy Law School now.
And what are you doing here? Just watching? the
No,
proceeding?
sir, I am doing an internship under former Advocate General, Sir Ramesh Chandrawat.
All right. So you have noticed that the prosecution has examined witnesses who are the close relatives of the accused persons.
Yes, sir.
And they have come and deposed in a manner which
is in
supports
support
the
of the
defense
defense,
case. These persons should not have been examined. They are not prosecution witnesses.
Indeed, your lordship.
So it is apparent that the prosecution didn't have a clarity on whom to examine as witness in support of the prosecution case. So this is one area the case has been weakened.
Yes, sir.
And if the prosecution evidence projects two contradictory theories, this is a good enough ground to give acquittal on the basis of benefit of doubt. What else have you observed?
The defense is trying to defend the appellant on the basis of the 9 months gap, that is from the the demand of dowry and the 9 months gap after where the incident took occur. And there is a case law where it is clearly mentioned that it does not require to prove section 304B. The time limit is not required. Only the requirement is that the dowry and the death should be interconnected. So the 9 months gap is completely.
All right, so would you be available day after tomorrow? Will you come to court?
Yes, sir, definitely.
Would you like to go through the paper book and you can be there, and
Indeed, much
if
honest.
there is anything you want to, this is just an assistance on the legal issues. If you are interested, then we'll give you that opportunity.
Indeed, your lord.
But the case will be argued by the prosecutor only on legal issues. All right. So you can let him go through the paper book of the appeal. You go through it here. And day after tomorrow, you will be present if there is
Indeed, your
anything.
lordship, I will present.
Yes, yes. If you have any things to, we find that you have a fairly good understanding of the
Indeed, your lord.
criminal jurisprudence, and we appreciate that.
Much
Go
obliged.
do some more reading and see if there is something.
Indeed, your lord. Much obliged.
I will give him the paper book, my lord.
All right.
Deep level.
Lordship, kindly the matter may be adjourned only for the day, Lordship.
Oh, why?
Item 4, Lordship. On
We
the
don't
prayer
have
of
any
Mr.
other
A.
matter
Ahmed,
then.
Lordship. On the prayer of Mr. A. Ahmed, Lordship. Matter may be adjourned only for the day.
No, but why this final hearing cases, why suddenly adjournment prayers are being made?
Lordship, I'm appearing on behalf of Mr. A. Ahmed Lordship. He's on election in another
That you
court.
have said.
Lordship.
Why does he want an adjournment? He was here
Because-
this morning, he argued the matter.
Lordship,
Then some more important case somewhere.
Lordship.
All the cases are important.
On the prayer of Mr. A. Ahmed, Nayak, counsel for the appellant, this hearing of this appeal stands adjourned.
Yes, Lordship.
There.
Adjournment.
Item number 4, that may be adjourned. also.
But you have written that you are not available, so you want the adjournment, and you are making that same
I
submission.
have just come.
All right, adjourned.
All right.
Item 5.
May I please, your Lordship?
Yes, please.
In this matter, my lord, accused person has been convicted on the death of his wife, my lord. There is a quarrel between them as per prosecution case, my lord,
Mhm.
to which
This is a jail appeal.
jail appeal, my lord.
Okay.
Out of burn injury that this is died, my lord.
Just a minute.
My lord.
Yes, let us start with the Ejahar.
My lord. Ejahar at page 4, my lord.
Page.
Page 4 of the paper book. May I read, my lord?
Yes.
I have the honor to state that informant is the mother of the deceased, my lord. I have the honor of the, to state that about 12 years ago, my daughter Srimati Sumi Agarwal got married to Sri Rupak Sonowal, son of Sri Kula Sonowal, resident of Nagini Juri, Mirigao, Post Office Mirigao, PS Borhola, District Jorhat. Rupak had been torturing my daughter physically as well as mentally since some days back. Around 4:30 p.m. on 31st of 01/2018, while my daughter was in a meeting of group at the house of Sri Keshav Sonowal of the same village, Rupak verbally abused her, brought her to his house and uttered, "I shall finish you off," in presence of the women of the meeting. After a short while, smoke emitted from the house of the commotion was raised. The people who had gathered in a nearby house for some function came to the house of the accused and found both the doors to his house shut. Thereafter, recovering my daughter Sumi Sonowal in a burnt state, we got her admitted into Jorhat Medical College around 7:15 a.m. yesterday. She died at the hospital. The death of my daughter as a result of the tortures meted out to her has pained me much, and therefore I earnestly request your good self to be kind enough to ascertain the cause of death.
All right. So what is the evidence from the prosecution side?
There are 14 evidences.
Important
are there.
witnesses, yes. So
Witnesses
this
are
is a
there,
case of circumstantial evidence.
my lord.
Any
As
dying
the-
declaration?
Yes, my lord. TW 9 and 10
Hmm.
makes statement regarding the statement of deceased, corroborating the statement of deceased, my lord,
Hmm.
that she burned herself. That part of evidence is discarded, the learned court.
This is an oral dying declaration?
Orally, my lord, while she
Not
was,
recorded.
no, my lord, because that timing of the event, till she was taken to the hospital. In between, these are the persons who kept her, who carried her, admitted the hospital, my lord.
Hmm.
In between, she said herself that she burned herself, my lord. That much is 9 and 10.
This was told by the prosecution witnesses.
Yes, my lord. They are independent witnesses, my lord.
Hmm.
Other prior incident, the prior evidences are from that family members, my lord.
So who are the independent witnesses here?
They are neighbors, my lord.
No, give us the PW numbers.
Page 9 and 10, my lord.
What are the PW numbers?
My lord.
PW numbers,
PW number 9 and PW number 10.
9 and 10.
10, my lord.
Okay, let us read their testimony first.
Page 28 is the evidence of 9, my lord. PW 9.
Yes.
I know the informant as well as accused. I knew Sumi. She was a wife, was the wife of the accused. The incident took place on 31/1/18 and Sumi died on 1/2/2018. At the time of occurrence, I was busy with a prayer meeting held nearby. That day, my youngest son told me over phone, "Aunt got burned. Please come soon." Then I went to Sumi Sonwal's house. Going there, I found Sumi kept laid on the ground on the veranda. At the time, she was able to speak. She told me that she herself caught fire. Thereafter, we got her admitted into Medical College Hospital. Sumi sustained 99% burns. Her face and other portion of her portion, except soles, got burned. There used to be frequent quarrels between the accused and Sumi. Rupak works as a driver, and whenever he came home, they used to quarrel. The pond is about 4 meters away from the house. Because this line was there because she was, after that burning injury, she was carried out to the pond, my lord, so that healing touch can be given, my lord. But who carried her to that particular place, it was not evident from the witnesses, my lord.
Hmm.
So he discovered this person, this is person at this stage, my lord. In cross, the house of the accused is about 10 meters away from mine. Quarrels used to take place between the accused and Sumi over family issues. Next one is page 30, my lord. PW 10. I know informant as well as accused. I knew this is Sumi Sonwal. About 10-15 years ago, this is Sumi Sonwal got married to the accused, and from then they had been living as husband and wife. The incident took place about 5 months ago. That day a quarrel took place between Rupak and his wife. Rupak came out and raised hue and cry that his house had caught fire. At that time, I was sitting at a nearby house, and from there, I went to Rupak's house with a bucket of water. Then I saw Sumi Sonwal in entirely burnt state. The house was not on fire. Entering through the back door, when I saw Sumi in that state, I got frightened and went out to the road. I found Sumi on the doorway, and at that time, I saw her trying to come outside. Later, when people came, I again went there and saw Sumi lying on the bank of the pond. Sumi said that she herself got burned. I brought her to the hospital. At that time, only Sumi and the accused were there. My house is adjacent to that of the accused. They have 2 children. That day, there was a prayer meeting in our village, and their children were present at that
Ms. Bhuya, just see the 161 of this person, PW 10. What did he tell the police?
Raju Sonwal and Ajoy Sonwal.
Lordship, may I read?
Yes, please.
Statement of Raju Sonwal, my lord, PW 9.
9.
মোৰ নাম আৰু ঠিকনা ওপৰত উল্লেখ কৰা মতে সত্য হয়। মোৰ ঘৰত পত্নী আৰু ল'ৰা ছোৱালী আছে। মোৰ ঘৰ ৰূপকৰ ঘৰৰ কাষতে। সেইদিনা মই গাঁৱত হোৱা নামত আছিলো। মোৰ ঘৰৰ পৰা ফোন কৰি জনাতহে মই গম পাওঁ। উক্ত দিনা তেওঁলোকৰ মাজত কি হৈছিল মই নাজানো। কিন্তু দুয়োটাৰ মাজত কাজিয়া হৈ থকা মই গম পাওঁ। কি কাৰণে হয় মই নাজানো। That is the statement of Raju Sonwal. Then Ajoy Sonwal, my lord. মোৰ নাম ঠিকনা ওপৰত উল্লেখ কৰা মতে সত্য। মোৰ ঘৰত মা দেউতা নবৌ মোৰ পত্নী ছোৱালী আৰু ভতিজা আছে। মই ৰাস্তাত আছিলো। ৰূপকে ঘৰৰ জ্বলিলে বুলি চিঞৰাত মই পানী এটিং লৈ তাৰ ঘৰলৈ যাওঁ। ঘৰৰ ভিতৰত মানুহজনী জ্বলা বুলি কয় আৰু সি পদূলিৰ ওচৰত ৰৈ আছে। মই গৈ ঘৰ জ্বলা নাপালো, কিন্তু তাৰ পত্নী চুমিক জ্বলা অৱস্থাত পাওঁ। মোৰ অনুমান সিয়ে তাইক জ্বলাই মাৰিলে। এই মোৰ ক'ব লগা।
So,
Position is-
he said something else to
Yes,
the
ma'am.
police. And in his deposition, he says that the victim told him that she had
Yes,
burned
there's
herself.
nothing.
But he did not say that before the IO.
No.
So this is a clear improvement.
Yes, ma'am.
But in any case, he is a prosecution witness. He is not declared hostile. You
What
can
to say
dictate the
here?
judgment just now,
দুটাই নেকি তাৰ?
unless you have something else to say. Ms. Bhuya.
Prosecution witness declared hostile, my lord. And
No, no, these two persons
these
are
two are not declared hostile by the prosecution.
Will it not be binding on the prosecution?
Lordship, 161, if you would have told before the IO, and in substantive evidence, if he denies, then your lordship, he should be declared
No,
hostile.
no. See,
64 is before.
he could have been,
64, okay.
what is it?
16 also, I don't have the paper, that is my lecture.
You don't have the
I
paper.
don't have. For a record and so.
Then how will you conduct the hearing? Why no paperwork was given to you?
Lordship, maybe it was misplaced somewhere. 4-5 maybe. Five.
Then you must examine this matter, because these are all cases of, you see, life imprisonment and 302 convictions.
Misplaced for my person.
But what we are asking you is something
Yes,
else.
yes, ma'am.
See, there is obviously no eyewitness. The circumstances is what the court will have to interpret. The husband was inside, there was a quarrel. Now, did the quarrel lead to the accused putting the victim on fire, or did she, out of a fit of rage, poured kerosene on her and burned? Both these are possibilities.
Yes.
If the second thing happened, the question of conviction doesn't arise. Now, how do you decide that? Only on the basis of materials on record, nothing else?
There is no such
Tomorrow.
material, my lord.
Huh?
To that extent, lordship's query, to answer the query, my lord, there is no such has.
That is what you have just said.
Come out
We
from
have
the
just opened the
evidences.
file just now. But the point here is that this witness PW10,
My lord.
he has punctured the prosecution case. He is not a hostile witness. Therefore, his evidence has gone in unrebutted, and according to which the victim is the case of self-immolation. How can there be conviction under
Yes, ma'am.
302? That's
That is
the
right.
long and short of the matter. What
Yes,
else is
madam,
there?
yes.
What else is there? How can you on some presumption and some, there's nothing else. What did the accused person say in his 313?
313, yes, my lord, there is a statement. Last question.
But if you don't have the paper book, then it's a risky proposition. Tomorrow.
I may be accommodated, my lord, if I have in some other court, my lord.
We'll just go through the evidence once and then
Yes.
we'll,
If
we'll-
lordship permitted me, I can do my part, my lord,
we'll do it.
Yes.
Adjourning right away,
my lord.
but you must get a chance to go through the
Yes.
paper book.
I'll provide the paper book to my learned payment,
All right, but why? Can the registry not? give it?
44 months.
Acha, all right, what does the accused person say in his 313,
Page 44, my lord.
page 44?
Yes,
Yes,
it's 313 deposition, my lord.
yes,
Relevant answer is page 48, my lord. Question number 25, last.
Hmm.
Do you want to say anything in your favor? By profession, answer is my profession, I am truck driver. On the date of incident in the morning time, I came to my residence and after taking my breakfast, I was standing on the road. And at that time, I had seen fume inside my residence, due to which I ran to my residence and saw Sumi was on fire. Then I tried to set ablaze the fire from the body of my wife by covering her body with a blanket, due to which I had also received some burn injury. Although I had shouted for help, but none came forward to help me, and later on I became senseless. I can't say who had taken my wife to hospital.
so is there any burn injury suffered by him, the appellant
Uh,
here?
Yes, my lord,
Some injury report is there?
no evidence was on that point, my lord, that he is suffering some burn injury, but it is his statement, my lord, I found. It is his statement only, one thing,
And how it has been dealt with by the trial court?
my lord. So far as 131,
Let us see the relevant finding of the trial court.
my lord.
Mr. Buragoy, you are waiting for some matter. Do you have anything to say? Yes.
Lordship may turn to page 59, where from paragraph 36 onward, that reasoning comes, my lord.
Yes, yes. Let us read it.
Earlier part is that evidence
Yes.
Learned trial court has discussed, my lord. From the discussions made above, it can be seen that the case of the prosecution is based on a circumstantial evidence. Being based on circumstantial evidence, prosecution relied on the following circumstances to establish that the accused intentionally caused the death of his wife, Sumi Sonwal, and is therefore guilty of committing murder. A, the deceased was attending the meeting of self-help group in the village on the day of the incident when the accused went there and using filthy language brought the deceased home from there. B, the accused while bringing the deceased from the meeting told her that to suffer them. C, the only accused and the deceased were at home when the fire took place. D, the deceased was taken by the public to GMCH, where she died as a result of burn injuries. As per prosecution, the above circumstances from a complete chain establishing guilt of accused, and he should be held guilty of the offense of intentionally causing the death of his wife, Sumi Sonwal, and punished under section 302 IPC. On the other hand, the defense of the accused is that the oral lying declaration made by the deceased before PW9, Raju Sonwal, and PW10, Ajoy Sonwal, to the effect that she got burned herself was sufficient to absolve the accused from the alleged offense he has been charged with. As per the learned counsel for the accused, PW9 and PW10, has not been declared hostile by the prosecution, and as such, their evidence may be accepted in toto, and the accused may be acquitted, giving him the benefit of doubt. Now, let me examine the evidence of PW 9 Raju Sunwal and PW 10 Ajoy Sunwal with regard to the alleged oral dying declaration made by the deceased before them. If the defense is able to show that the deceased did make her oral dying declaration before PW 9 Raju Sonwal and PW 10 Ajoy Sonwal, and if the said evidence is found to be worthy of acceptance and credible, then the said defense of the accused would have to be accepted. Before proceeding to scrutinize the legal acceptability of the oral dying declaration, I consider it appropriate to refer to certain decisions in regard to the admissibility and evidentiary value of the dying declaration. Thereafter, the case laws are discussed, my lord. Kindly turn to page 65, para 53, my lord. After discussion of
Yes.
the reasoning, my lord. Oral line declaration is no doubt an important piece of evidence, but it should be free from all infirmities. There is no other corroboration apart from the one-line statement of PW 9 and PW 10 made in their deposition before court that the deceased stated that she got burned on her own. The conduct of PW 9 and PW 10 is highly unnatural that they did not inform anybody about the alleged oral dying declaration. There is no explanation as to why they did not inform anybody earlier before the deposition made in court that the deceased said she burned herself. It has come on record that deceased had suffered 90% burn injuries and she expired in the hospital on 1/2/2018 at 7 a.m. Given the seriousness of her condition, it is highly improbable that she was in a position to make any oral dying declaration to PW 9 and PW 10. There are serious infirmities in the evidence regarding the oral dying declaration. I therefore consider that it is highly unsafe to place any reliance on the alleged oral dying declaration because of the many infirmities as stated herein above. On overall view of the matter, the evidence of PW 9 and PW 10 that the deceased gave oral dying declaration before them absolving the accused does not inspire any confidence.
No, but this has created a very peculiar situation that the trial court is not believing the prosecution witness and convicting the accused person on the basis of then what evidence? They were almost treated like defense witness, not prosecution witness. Anyway, you please proceed. We'll have a view of the matter and then we'll close it tomorrow so that she
My
can
lord.
respond. Yes.
Next parameter, having held so, now let me examine if the prosecution has been successful in completing the chain of
This will come
circumstances.
in the list now tomorrow. You can just inform them. We'll pass an order, but inform them that this matter has to be, yes.
If the prosecution has been successful in completing the chain of circumstance to connect the accused with the offense he is charged with in the present case, there is no witness of the occurrence that it is only based on circumstantial evidence. Before moving further, I consider it appropriate to refer the law regarding reliability of circumstantial evidence to acquit or convict an accused. Thereafter, the case laws are discussed, my lord.
Mhm. Yes.
Page 71, after subpara 69, 67, my lord. 68 paragraph, my lord. However,
You are referring to which page?
My lord, page 66, para 57, my lord.
Yes,
I have carefully considered the evidence, materials on record, and the rival contentions of the learned counsel for the parties. Admittedly, there is no eyewitness and the prosecution case is based on circumstantial evidence. The circumstance as can be called out from the evidence and material on record and relied upon by the prosecution to bring home the offense which the accused in charge are as follows. A. No social marriage had taken place between the deceased and the accused, though they were living together in a matrimonial relationship as husband and wife for more than 12 years, which was confirmed by PW1 and PW11. PW1 has stated in her deposition that her daughter did not stay in peace at her matrimonial home. PW3 also deposed that there was marital discord between the accused and the deceased. PW5, PW8, PW9, and PW10 also deposed that there was frequent quarrel between the accused and the deceased. Prompted by this motive, the accused eliminated the deceased on the fateful day. B. PW2 has deposed that when the deceased was attending the meeting of self-help group in a village on the day of incident, the accused went there and using filthy language brought the deceased home from the meeting. The said fact stood corroborated from the deposition of PW5, who deposed that accused brought the deceased from the meeting and admittedly thereafter there was hue and cry in the house of the accused and deceased sister-in-law came to place where they were singing devotional song and told that the accused got burned. Deceased got burned. Sorry, ma'am. The incident took place inside the house of the accused and immediately after deceased was brought by the accused from the self-help group meeting. PW8 has deposed that on the day of the incident at around 4 p.m., she had gone to tube well to bring water. At that time, she heard that deceased and the accused were fighting and went to their house. The accused was fighting with the deceased by closing the door of the house. When she called them, the deceased opened the door crying and told her by crying how much more she had to tolerate, and then accused told the deceased to leave the house and abused her with bad words. She pacified both of them and came to her house. The deceased was last seen with the accused. It is settled legal proposition that the law presumes that it is the person who was last seen with the deceased would have killed the deceased and the burden to rebut the same lines on the accused to prove that he had departed. The last seen theory is an important evidence in the chain of circumstances that would completely establish and or would point to the guilt of the accused with some certainty. In the present case, the accused failed to rebut the presumption of the last seen theory. Only the accused and the deceased were at home when the incident is alleged to have taken place inside the house of the accused. PW5 has deposed that at the time of incident, accused and his wife were present at home. PW10 deposed that at the time of incident, the children of the parties were present at the devotional song prayer meeting. In such circumstances, the accused had all the opportunity to commit the offense. The incident is an evening time incident stated to have occurred at about 4 p.m. inside the house occupied admittedly by the accused with his deceased wife. The incident has happened in the same premises and the body of the deceased in a burned state was recovered from the same premises as evident from the inquest report. Next page, my lord. PW5 deposed that when they went to the house of the accused on hearing the news of the burning of the accused, this is Sumi Sonwal, they found the accused in the garden and told that there was burning. PW7 deposed that they found the accused standing near the gate of his house, and accused told him that it should be his, my lord. His
Yes.
house is burning. PW8 deposed that after finishing her household work, when she came to the garden, she heard hue and cry and again went to the house of the accused, and accused was shouting that his house was on fire. PW10 deposed that he saw the deceased in a burnt state and the house was not on fire. Had the accused not committed the crime, he would not have misguided the people by tale that his house was on fire instead of informing that his wife tried to commit suicide by burning, as is his defense under section 313 CRPC statement. PW8 deposed that she saw the deceased lying inside the water and her head would be seen above the water. PW7 has deposed that he was the deceased lying in a burnt state near water and portion below the waist was inside the water. He brought the deceased to the veranda and villagers took the deceased to the hospital. PW1 and PW2 who are 11 who are mother and father respectively of the deceased deposed that the deceased was asking to taken to hospital. This coupled with the fact that PW7 found the deceased near the water with half her body immersed in water are itself indicative of the fact that the deceased tried to save herself from the fire set on her body by the deceased by immersing herself in water and later by asking to taken to the hospital. Had the deceased committed suicide, she would not have attempted to douse the fire by immersing herself in water and asked to take her to the doctor. These factors negative the defense of the accused that the deceased tried to commit suicide by setting herself on fire. PW1 deposed that when the deceased Sumi Sonowal was lying in the veranda, the accused went to his mother's house. PW6 deposed that incident took place at 5 p.m. and accused was not present at the time and the deceased was lying on the veranda. The accused had no plausible explanation for running away from the place of occurrence, leaving his burning wife on the veranda. It was the villagers who brought the victim to the hospital where she breathed her last at 7 a.m. The accused surrendered only on 7/2/2018. If the accused had not intentionally killed the deceased Sumi Sonowal by setting her on fire, there was no reason for him to abscond for a week after the incident. The accused had no plausible explanation to offer as to the burn injuries on the deceased and the date of the deceased Sumi Sonowal. The accused sustained only 30% burn injuries, whereas the deceased sustained 90% burn injuries. The presence of the burn injuries found on the body of the accused are indicative that the deceased tried to save herself from the accused, as a result of which there had been a struggle and the corresponding burn injuries on the accused. The deceased was taken by the public to GMCH where she died as a result of burn injuries. PW5 deposed that the deceased got burned at 5 p.m. and next day expired at 7 a.m. CW1 Dipansi Datta deposed that on 1/2/2018, she was working at Jorhat and on the said day she went for inquest at JMCH in connection with Jorhat PSGD entry number 391. The name of the deceased was Sumi Sonowal and she got burned as a result of fire. PW14 deposed that burn injuries of the deceased are epidermal and demoepidermal in nature and covers approximately 90% of total body surface area. Opinion as to cause of death was that Death was due to shock as a result of burn injuries sustained at described. Burn injury was antemortem and covers approximately 90% of the total body of the surface area. Inquest report and medical evidence supports prosecution version that the death was homicidal and due to shock as a result of antemortem burn injury. In every case, based upon circumstantial evidence, in this case as well, the question that needs to be determined is whether the circumstance relied upon by the prosecution are proved by reliable and cogent evidence, and whether all the links in the chain circumstances are complete so as to rule out the possibility of innocence of accused. There is no doubt that conviction can be based on solely on the circumstantial evidence, but it should be stated that a touchstone of the law relating to circumstantial evidence, these are the 59 onwards, my lord, cases are discussed relating to issues, my lord. In para 66, page 71, my lord. In the present case, at the time of date, except the deceased Sumi Sonwal and accused Rupak Sonwal, no one else were present in the house of accused at that time. Therefore, in the instant case, an adverse presumption has to be drawn against the accused that he had caused the burn injuries to the deceased Sumi Sonwal and committed her murder by intentionally causing her death. The ratio of the decision in the case of the so-and-so versus so-and-so are squarely applicable to the facts of the circumstance in the instant case. So here lies only that presumption of doing the act, my lord. Next para 67, second para, my lord. In the instant case, prosecution has discharged its initial burden of bringing the circumstances on record that are sufficient to establish the links of this chain of events to establish that it is a case of homicide amounting to murder. Accordingly, the onus is shifted on the defense to explain as to how and in what circumstances the deceased Sumi Sonwal met her death. However, the accused did not explain under what circumstances the deceased sustained the burn injuries inside their house. The accused is unable to discharge his burden by giving any explanation or coming forward with an explanation about the circumstances in which the deceased could have.
So, all right, these findings are not correct.
My-
The Learned Trial Court is not correct in these findings. This is almost shifting the burden.
Yes,
Accused has given an explanation, but that explanation is not correct. He said after breakfast, he was going out and then, but the incident happened in the evening,
Yes.
my lord.
5 p.m.
In fact, his version doesn't tell you with the prosecution witnesses.
That's
also.
correct. We will go through the evidence, we'll continue with
Fine.
this matter. But we will also examine whether the the conviction can be converted to 306.
Yes.
My-
That is an angle we'll examine.
My lord,
So we are keeping you noted on that.
my lord.
Because there is evidence to show that there was a quarrel that day and he pulled her out of some religious meeting. So this quarrel, and he was cursing the victim by saying that we'll teach him your lesson or something, whatever. So this could be some form of instigation that the victim ultimately just lost her self-control and wanted to finish her. So the evidence, PW9, I have not seen where he has said about the dying declaration, but PW10 has said it.
Yes,
His evidence, he was not confronted. There is no contradiction. Even if there is an improvement, there is a prosecution witness. Prosecution cannot wriggle out of that. So the father, PW11 says she was in a position to speak. PW1 says she was in a position to speak. She said, take me to the hospital. Of course, they were not present.
yes,
PW11 was-
father get known that incident after 10 hours or like
Yes,
that
he
in
came
in
after
this
10 hours.
deposition, yes.
But that this part of the evidence has gone unrebutted. So looks like it is a case where being completely frustrated with the behavior of the appellant,
Yes,
she took this extreme step of self-immolation. And his explanation is weird, it is not correct. And then he was absconding for about 7 days, absconding not in the sense of CRPC, but he was not to be found. After 7 days he came, so there was a sense of, you see, guilt consciousness on him. So even if he has not set the victim ablaze, we find that there is sufficient evidence to conclude that he is the instigator. Because of him, the lady set herself ablaze. So then why would it not be a case under
306.
what do you have to say also? You also take note of this.
my lord.
But let us just go through the evidence.
Yes,
First of all, where does PW9 say about the dying declaration? Where is it? I have not, let's come to it again.
it's not exactly dying declaration. Page 29, my lord, kindly peruse.
Yes.
I found Sumi Cave laid on the ground on the veranda. At that time, she was able to
She
speak.
told me that she herself caught fire. Yes, that
see.
she.
That line is there.
And that is corroborated by PW10,
10, my lord.
both of whom are independent witnesses.
Independent. Both are cultivated and happen to be neighbor, my lord.
That part of evidence will be binding on the prosecution. Minute? 302 conviction, not possible. So let us quickly read the evidence of PW1 onwards.
My lord.
Hmm.
Page
Mother.
9(1), my lord. The accused is my son-in-law. I am informant in this case. About 12 years ago, my daughter Sumi Sonwal got married to the accused. She has left a son and a daughter. The incident took place on 31/1/2018. My daughter never lived peacefully in the house of the accused. Around 4 p.m. on the day of occurrence, I was at the house of Lanka attending a prayer ritual. Ripsmita Sonwal informed me that my daughter had got burned. The house of my daughter's husband is apart 2 houses from mine. Upon receiving the information, I went running to my daughter's house and saw her in a burnt state. My daughter was asking to take her to the hospital. Madhurya told me that prior to occurrence, a quarrel took place between the accused and my daughter. Earlier, my daughter had told me that sometimes quarrels used to take place between the accused and her. My daughter was in a meeting before the incident and accused brought her to his house wherefrom while abusing her verbally. Punya Sharma told this to me. Thereafter, I lodged a Ejahar with the police station. Exhibit 1 is Ejahar. Since the accused was inside the house when my daughter got burned, I assumed that accused might have set my daughter ablaze. My daughter was lying on the veranda and accused fled to his mother's house. The accused did not go to see my daughter. In cross, the marriage between the accused and my daughter was not solemnized socially. I did not state to police that my daughter never lived peacefully in the house of the accused. It is not a fact that I did not state to police that Ripsmita informed me that my daughter had caught fire. I don't remember whether I stated to police that upon receiving the information, I went running to my daughter's house and saw her in a burnt state, that my daughter was asking to take her to the hospital. That Madhurya told me that prior to the occurrence, a quarrel took place between accused and my daughter, and that Punya Sharma told me that before the occurrence, my daughter was in a meeting and accused brought her home from there. I did not state to police that when my daughter was lying in a veranda, the accused fled to his mother's house. It is not a fact that the accused sustained injury in his chest while trying to douse the fire, which he had set to my daughter. I heard that the accused had undergone treatment in the hospital for his burn. I don't know how long he had undergone treatment. It is not a fact that my daughter committed suicide. I lost the Ejahar after 2 days of the incident. I did not mention the cause of delay of 2 days in losing the Ejahar because I did not know that it needed to be mentioned. I don't know the name of the writer of the Ejahar. It was written by a person of Women Association. It is not a fact that I have adduced false evidence today. PW2, page 12, my lord. I know the informant, the accused is my brother-in-law. This is Sumi Sonwal was my sister-in-law. After her marriage, she used to live in her husband's house. 2 children were born to them. The incident took place on 31/1/2018. That day, Sumi had gone to attend some works of Mohila Gut. The accused went there to bring her home by abusing her verbally. On the previous day of the incident, the accused went to his house. After bringing my cattle from the field at 4 p.m., I saw the Sumi had got burned. Thereafter, I saw the victim when she was taken to the hospital. In cross, I don't know how Sumi got burned. I don't know if the accused had also sustained burns. Page 14, PW3. I know the accused as well as the informant. The accused is my brother-in-law. About 14-15 years ago, Sumi Sonwal got married to the accused. After her marriage, she led to conjugal life with her husband in house of her husband. Quarrels used to take place between them sometimes. On the day of occurrence, there was a prayer ceremony and a meeting in the village. While I was at the prayer ritual, my niece informed me that something had happened to Sumi Sonwal. My niece told me that fire caught the house of the accused. I came home after half an hour. The accused house is apart 4-5 houses from mine. I heard that Sumi got burned, but I don't know how she got burned. I am the secretary of a self-help group. Sumi Sonwal was not a member to our group. I heard that on the day of occurrence, the accused has brought Sumi Sonwal home from the meeting of the group. Ross, I did not state to police that quarrels used to take place between the accused and the victim. It is not a fact that I did not state to police about my niece informing me that the house of the accused caught fire. I did not come to the house of the Sumi Sonwal, and I also don't know how she caught fire. I heard from someone that she was brought home from the meeting of the self-help group. Page 16, PW4. I know the informant as well as accused. Victim Sumi Sonwal was the daughter of informant and she was married to the accused. They have 2 sons. The incident took place on 31/1/2018. On the day of occurrence, there was a prayer ceremony in the village and I was busy working there. Sumi's sister-in-law went there and shouted that Sumi had caught fire. After that, though we went to the front of Sumi's house, we did not enter the house. In cross, I don't know how Sumi got burned. Page 18, PW5. I know the informant as well as accused. I know this is Sumi Sonwal. The deceased was the wife of the accused. There used to be frequent quarrel between the accused and the deceased, but I don't know the cause behind it. On the day of occurrence, Sumi had gone to the meeting of the self-help group. Later, the accused called Sumi home from there. After some time, a commotion took place at the house of the accused and Sumi's sister-in-law came to the place where we were attending a prayer meeting and said that Sumi had caught fire. The house of the accused and that of Sumi's sister-in-law are adjacent to each other. From there, we came to Sumi's house and on the way, we came across the accused and told us that Sumi got burned. At that time of occurrence, the accused and his wife were present at home. She caught fire at about 5 p.m. on Wednesday and died at about 7 p.m. on the following. I heard that accused brought Sumi home from the meeting of the self-help group by scolding her. Cross. I did not state to police that frequent quarrels used to take place between the accused and his wife. I did not state to police that Sumi's sister-in-law came to the place where the prayer meeting was going on and told that Sumi got burned. It is not a fact that I did not tell police that Rupak told us on the road that Sumi had got burned. I did not state to police that Rupak brought his wife home from the meeting of the self-help group by scolding her. I don't know how Sumi caught fire. I did not see whether Rupak was present at home or not. PW6, page 20. I know the informant as well as accused. The houses of the accused and informant are adjacent to each other. Their houses are something omitted, my lord, away from the house. The deceased was the wife of the accused. The incident took place at about 5 p.m. on the day about 6 months back. On the day of occurrence, there was a prayer meeting in the house of the village, and I too was present there. After that, Sumi's sister-in-law came to the place where we were attending the prayer and said that Sumi had caught fire. Then we immediately went to see what had happened. Sumi's mother told us in tears that after bringing Sumi from the meeting of the self-help group, she was killed. I found Sumi kept covered with a cloth at the veranda. I did not see the accused. Most portion of the Sumi's person got burned. I did not know who set fire to Sumi. Since I am not on visiting terms with the accused, I don't know if accused used to inflict tortures on her. At this stage, prosecution witness is declared hostile at the prayer of prosecution. It is not a fact that I stated to police in such terms. Later, I came to know that her husband Rupak had killed her by setting fire to her after pouring oil on her as he fled from his house. In haste after setting fire to her. Prior to that, also Rupak used to inflict tortures on her. It is not a fact that I have adduced false evidence for the sake of the accused. I did not state to police that Sumi's sister-in-law had informed us that Sumi got burned. It is not a fact that I did not state to police that Sumi's mother told us in tears that after bringing Sumi from the meeting of the self-help group, she was killed. I did not see Sumi being brought from the meeting of the self-help group. I did not state to police what have been written in the court today to have been stated to police. I cannot say how Sumi caught fire. PW7, page 23. I know the accused as well as informant. The accused had married my uncle's daughter. Sumi was the daughter of my uncle. The occurrence took place at around 4 p.m. on the day about 3 months back. At that time, I was returning home from Namghar. On the gateway of accused house, the accused told me that his house was on fire, but I saw that his house did not catch fire. Then he told me that was lying at the backside, and so I went to him to the backside of his house, whereupon I saw Sumi lying near the water in a burned state. The portion of her body below the waist was in the water of the pond. Then I raised hue and cry and lifted her to the veranda. Later, the people came and took Sumi to hospital. On the following day, Sumi died in the hospital. My house is situated adjacent to that of the accused. Cross. It is not a fact that I did not state to police that I was returning home from the Namghar. It is not a fact that Rupak did not tell me that his house was on fire. It is not a fact that I did not state that when I saw Sumi, the lower portion of her body was in a water of the pond. It is not a fact that I did not state that thereafter I carried Sumi to the veranda and kept her laid there. I don't know how Sumi caught fire, and so I can't say. PW8, page 25. I know the accused. The deceased was wife of the accused. The informant is my mother-in-law. The accused and the deceased lived as husband and wife. They lived near our house. Quarrels used to take place between them sometimes. The incident took place on 31/1/2018. On the said day, Sumi died from burns. There is a tube well by the side of the road in between the house of the accused and ours. Around 4 PM on the said day, I had gone to the tube well to fetch water. At that time, hearing the accused and Sumi quarreling, I kept the pot near the tube well and went to their house. The accused and his wife were quarreling inside their house with the doors closed. When I called, Sumi opened the door crying. Sumi asked me in tears as to how long she would have to bear the pain, and then the accused rebuked her in filthy language and asked her to get out of the house. I tried to pacify both of them and return home. After doing my household chorus, when I came to the road, I heard the commotion, whereupon I again went to the house of the accused and saw Rupak shouting that his house was on fire. As the articles in the first room had got fire, I tried to enter through the back door, and then I saw Sumi lying in the pond in a burnt state. Only Sumi's head was lying above the water. Then I screamed, went to the place where her parents were attending a prayer and gave them the information. After that, I became unable to say anything. Sumi died at Jorhat Civil Hospital on the following day. Cross. It is not a fact that I did not state that when I called. Sumi opened the door crying that Sumi asked me in tears as to how long she would have to bear the pain. That when the accused rebuked her in filthy language and asked her to go out of the house, that I tried to pacify both of them and return home. That after doing my household chores, when I came to the road, I heard commotion, whereupon I again went to the house of the accused and saw Rupak shouting that his house was on fire. That as the articles in the first room had caught fire, I tried to enter through the back door, and then I saw Sumi lying in the pond in the burnt state, and then I screamed, went to the place where her parents were attending a prayer and gave them the information. Since police did not ask me, I did not state to them that quarrels used to take place between them sometimes. It is not a fact that I have adduced false evidence as tutored by my mother-in-law. Then PW 9.
Yeah, just take out this 161 of PW 8. We'll come to it, just go through it, what she has stated. PW 9 we have read already.
My lord, 9 and
9
10,
and 10. 11 also, father, he was not there.
not
Came
there, my
after
lord.
10. After 10 hours.
Yes. PW 12 is the doctor, my lord.
So he says it's burn injury,
Yes.
abdomen except the feet and back of abdomen, everything, there was burn everywhere, 90%.
Yes, in page 35, my lord, he also examined the ligature mark in the neck. It is not found there, my lord. Marks for ligature on neck, dissection, etc. No ligature mark is detected around the neck on research dissection underlying neck tissue or
So
found.
that was due to burn injury.
Right.
4 to 8 hours. And there was no cross of this. So all right.
Cross was declined, my lord, in respect of this evidence.
Who is PW 13?
13 is the brother, my lord, younger brother. I know the informant. The accused is my elder brother. This is Sumi Sonwal, was my sister-in-law. About 9-10 years ago, my elder brother married Sumi Sonwal. I do not stay with my elder brother. At the time of occurrence, I had gone to the field. My brother told me that my sister-in-law had caught fire. When I came to my elder brother's house and saw my sister-in-law kept laid on the ground on the veranda. My sister-in-law kept covered with a cloth, but I did not remove the cloth to see the injuries. I came to hospital with the victim. After undergoing treatment for one night, my sister-in-law died at the hospital. Exhibit 2 is the inquest report and 2 is my signature. Cross, I don't know how my sister-in-law got burned. PW 14, page 39.
He is the IO.
IO, I was on 2/2/2018, I was on duty as OC Barhola Police Station. That day, having received the azahar from informant, I registered a case and myself took up the investigation. Exhibit 1 to in Exhibit 1 is my signature with report. I questioned the informant as well as other witnesses who had accompanied her at the police station itself. After that, I went to the place of occurrence, that is the house of the accused at Dolkata, Naginijuri, Mirigaon. Going to the place of occurrence, I questioned the witnesses and drew the sketch map of the place of occurrence. Exhibit 4 is the sketch map of the map, and 4-1 is my signature. On 7/2/18, accused appeared at the police station. I interrogated the accused, arrested him and forwarded him to the court. On 27/2/18, the JMC at the JMC outpost sent us the SCD to us. Be it mentioned herein that going to the place of occurrence, I came to know that since the wife of the accused sustained burn injury, she was admitted into JMC and she died at the hospital. Having found materials of the involvement of the accused in the incident on 28/2/18, I submitted charge sheet against the accused for commission of offense under section 302 IPC. Exhibit 5 is the charge sheet and Exhibit 5-1 is my signature. By making ZD entry number 331 dated 1/2/2018, ASI Ranjin Gogoi of JMC outpost held inquest on the dead body of the victim. I recorded the statement of Bimoli Sonwal. She had stated to me in such terms. Later, I come to know that her husband, Rupok Sonwal had killed her by setting fire to her after pouring kerosene on her as he fled from his house. Prior to that, also Rupok used to inflict physical tortures on her. Cross. Makhoni Sonwal did not state to me that while her daughter was lying on the veranda, the accused fled from there to his mother's house. When Radha Sonwal met us on the road, she did not tell us that somebody had got burned. Vimoli Sonwal did not state to me that Sumi's mother told her that Sumi was killed after bringing her from so and so. It is not a fact that in her statement made to me, Bimoli Sonwal did not state that her husband Rupok Sonwal had killed her by setting fire on the after pouring kerosene on her as fled from his house in a run, and that prior to that also Rupok used to inflict physical torture on her. Biman Sonwal stated to me that Rupok told him that his house was on fire. It is not a fact that I submitted the charge sheet without investigating the case properly. Next one, CW1, my lord, page 42. This is the ADC Jorhat who has inquested, my lord.
All right, so she only says she has done the inquest.
Yes, my lord, nothing else.
What does the PW Act tell the IO? You know,
মোৰ নাম ঠিকনা আছে মোৰ ল'ৰা ছোৱালী দুটা মই টিউবৱেলৰ পৰা পানী আনিবলৈ গৈছিলো তেতিয়া সুমি আৰু ৰূপকৰ মাজত কাজিয়া হৈ থকা পাওঁ মই দুয়োটাকে বুজাই মেলি আহো তাৰপিছত মই পানী লৈ ঘৰ পাওঁতে চিঞৰ বাখৰ শুনা পাওঁ মই গৈ তাইক সুমিক পুখুৰীত আৰু ৰূপকক চোতালত হৈ থকা দেখা পাওঁ চোতালত উল্লেখযোগ্য যে থিয় হৈ থকা দেখা পাওঁ উল্লেখযোগ্য যে প্ৰথমবাৰ মই যাওঁতে পিছত দুয়োটাই দৰজা বন্ধ কৰি কাজিয়া কৰি আছিলে মই দৰজা ঢকিয়া হুলস্থুল কৰি দৰজা খোলাই ভিতৰত সোমাইছিলো মোৰ ধাৰণা সুমিক ৰূপকে খঙত জ্বলাই দিছে নতুবা তাইক গাত জুই লগাবলৈ বাধ্য কৰাইছে
this is good material for at least 306 conviction. So our tentative view is that, subject to tomorrow when we conclude it, that 302 conviction is not sustainable. The evidence of PW's 9 and 10 will be binding on the prosecution. And they say that she has set herself on fire, and that fits into the circumstances. It is not repugnant to the circumstances. What has happened is that there was a quarrel, and either the accused has set her on fire or she had herself set. So it appears that the latter is the case here. But the accused did have a role. He contributed to the incident. He instigated her.
Instigated,
By misbehavior, misdemeanor, pushed her to such a level that she was left with no option but to immolate herself. What about the children of the appellant?
Opposition listening.
Anything to show what has happened? They are living
no,
with
my
whom?
lord, in evidence part, I don't find anything regarding her children.
No, you are asking.
মানে আছে বুলি কৈছো, ক'ত আছে কেনেকে আছে সেইটো নাই।
Judgment expecting for the Afghanistan.
So far as
But Ms. N.
opposition part.
Burman, learned amicus curiae appearing for the appellant. Also heard Ms. M. Burman, also heard Ms. B. Bhuya, learned senior counsel, bracket APP Assam, bracket close, assisted by Mr. J. Das, learned counsel appearing for the state, who submits that she does not have the copy of the paper book and therefore be granted 1 day's time to prepare and argue the matter. Full stop. In view of the prayer made by Ms. Bhuya, register to list this appeal for further hearing as a fixed third matter again tomorrow, that is give the date.
Yes, sure. Fine.
So that is the, how will you get the paper book?
I'll get a Xerox from her.
Or else if you want help.
in the judgment 81, my lord, that keeping in view of the materials on record, this court is of the opinion that it is a fair to award compensation to the children of the deceased who has lost their mother, and their father is sentenced to imprisonment for life under the provision of section 357A CRPC. Hence, a copy of judgment.
Demand is an
Settled.
06 maximum punishment is for 10 years.
Hmm, 10 years.
Sorry,
10 years and fine.
so we'll consider that and finish the matter tomorrow. Yes, any other case? Part 2.
I took my chance to the prosecution. Tomorrow I will try again,
Tomorrow?
subject to
Yes,
time.
we'll take